Yes, Mr. Davenport. Morning. Just a second, we have to call him back.
The Caribbean Court of Justice, Original Jurisdiction. Hearing of the originating application AGOJ2021-001 between Ellis Richards Medical Benefits Board, Spencer Thomas and others, and the State of Trinidad and Tobago. The members of the panel are the Honorable Mr. Justice Saunders, President and Presiding Judge, the Honorable Mr. Justice Anderson, the Honorable Madam Justice Rajnath Lee, the Honorable Mr. Justice Burgess, and the Honorable Mr. Justice Jamada. Counsel, you may now enter your appearances.
As before, Special Counsel and Mr. Gregory Pantin, Mr. George Kiernan, not present in court, Mr. Eamon Courtney, SC, not present in court, Professor Matthew Happel, and Mr. Miguel Vasquez.
Your Honours, the appearances for the state as
Yes.
Your Honour, can I just talk about time to start with? I was guilty of occupying more time than I was allotted yesterday, and I'm grateful for that indulgence. I'm looking at the back end. We absolutely do not anticipate being anything like the 45 minutes that we've been allotted at the back of the day. So I will do my best to be within my 75 minutes here. But
sure.
If I don't, I promise you that I will make it up later. We're very grateful. This is an important case, as of course everybody is aware, with the potential to really make or break the Caribbean project at the extremes. We therefore, in particular, welcome the participation of the Secretariat. Eric Williams, the famous, of course, former Prime Minister of Trinidad and Tobago, had, amongst other people, clear and far-sighted views about the Caribbean economic development and integration. In his famous book, perhaps his second most famous book, From Columbus to Castro, he wrote, "The constitutional diversity of the Caribbean is matched by an appalling degree of economic fragmentation, totally absurd for so small an area. Fragmentation goes to such fantastic lengths as would make the angels weep." Dr. Williams remarked that the vertical ties of states in the region with metropolitan powers were being strengthened and frustrated the creation of horizontal ties between the states in the region. The states were vying with one another to entice metropolitan firms to establish branches and subsidiaries, of course. Against that background, CLF, CLECO, and the perhaps inaptly named British American were signal successes for horizontal regional integration, much like Republic Bank continues to be. The failure of regional champions, unsurprisingly, sent shockwaves throughout the region, shockwaves which the court will be very aware of. As the court can anticipate, there has been a great human cost, and I must convey that to you. People, I'm afraid, are dying in poverty as a consequence of this. The human toll in this case is not to be under-recognized. The story of this case is not, of course, just about legal issues and doctrines, but about the citizens who are affected. It's a story about inequity with which a class of Caribbean nationals have been treated. This rather inequitable and unfair treatment has severely impacted the lives of thousands of policyholders and their families across the Caribbean, many of whom have lost substantially all their savings, retirements, and pension benefits, leading to immeasurable hardships and many lamentable and woeful outcomes and stories, all with devastating impacts on their quality of life. The harsh realities for these affected nationals with connections to the Eastern Caribbean states include pensioners who live in penury, unable to live a dignified life on account of their pensions disappearing overnight, elderly persons unable to afford vital quality of life improving medical procedures or on account of their savings disappearing overnight, families torn apart because of the financial strain of lost savings, I'm afraid to say numerous instances of suicide, withdrawal of children from educational establishments because the savings set aside disappeared, closure of businesses due to loss of capital invested with British American, jobs lost because of business closures, emotional stress, and health disorders arising from lost funds. And if I was to pluck one particular human story from Grenada, it's that the farmers, the collective of about 4,000 odd farmers, have not been able to receive for many years the end of year nutmeg bonus on which they so greatly count. Every British American policyholder in the OECS who has suffered the loss of their savings and investment has this painful story of woe to tell about the impact of not benefiting from the return of their finances with British American. Oftentimes, stories are told by the survivors of the original policyholders who recall deathbed requests for them to keep fighting to get money back. And for early rhetoric about this being a regional problem requiring a regional solution. In reality, it's thousands of ordinary CARICOM nationals who've borne the brunt of the broken commitments and the moving of the regional goalposts from an all-inclusive CARICOM arrangement to an exclusive CARICOM, wherein the spoils are to be aggrandized by the jurisdiction where the assets are domiciled. BICO, the coordinating institution that dared to belie such an enormous exercise of injustice, deserved a challenge, is rooted in the fundamental belief in the idea of a single CARICOM. According to Mr. Hugh Dollard, BICO board member, the victory for British American policyholders is a victory for all of CARICOM, as equality of treatment is justice for everyone. Finally, on this point, BICO believes in and is firmly committed to obtaining justice for all of its members as an organization founded in the belief that every Caribbean citizen is equal before the law and deserving of justice at all times and under all circumstances. We believe firmly that the Caribbean Court of Justice is the right and competent body to make the fit and proper determination in this matter, and look forward to some sunshine after those means of rain. Can I just say, as an overview, the second part of my speech is why this court should find on a headline basis for the claimants. Then I'll turn to what the case is not about and what the case is about. So in a nutshell, the first and second claims, there is fundamental and insurmountable inconsistency in how Trinidad and Tobago have dealt with BICO and its policyholders. Two aspects in particular. Trinidad and Tobago treated BICO as part of the CLF group when it came to taking its assets and put them into the CLF group pot. But when it came to meeting BICO's liabilities, Trinidad and Tobago excluded it from the CLF group and from access to that pot into which its own assets had been placed. That is constitutive of discrimination of one type or another, whichever way it is looked at, and gives rise to a breach of Article 7 of the revised treaty. Third claim, Trinidad and Tobago created redress through that CLF group pot, which it reserved for nationals and selectively amended its legislation and used the CBTT powers, the central bank powers, to curtail remedies that would otherwise have been available to protect the rights of the claimants, and other remedies in terms of leverage and contractual power, and those claimants, of course, were consumers. And that gives rise to the breach of Article 184 and 7 claims. So what this case is not about, despite the attempts of our learned friends to make it about that, is not about regulatory misfeasance. The subject matter of this case is not that the central bank or Trinidad and Tobago were negligent in the regulation of the CLF group, that they were negligent in not spotting shortfalls in the statutory funds or pushing for those statutory funds to be completed, rather than after the event warning about the ignorance of the audit messages or the messages from the bank. That has not been the subject of complaint in this case, and deliberately so. Notably, also of CLICO, in the shortfall of the statutory funds. And it is not also about the causing of the failure of the CLF group. That is not what this case is about at all. And therefore, it is not a regulatory case. And because this is not a regulatory case, regulatory jurisdiction and its territorial limitation is irrelevant. And the case is even less about extraterritorial financial regulatory intervention. Third, what the case is not about, we also do not seek to establish a rule whereby member states have to bail out or reach debt restructuring, like cramming down arrangements in America, with struggling companies in other member states. This is not what this case is about. This case is finally not about going to bankrupt Trinidad and Tobago, notwithstanding over the years that this case has been developing, the constant reference to the cost of the exercise, the denouement and outcome. The sums potentially at stake, of course, make it a big case. And the amounts are, of course, significant, especially for the consumers. But the sums at stake, sort of circa $300 million out of the witness for the defendant's own mouth, are but a small fraction of the overall capitalization of CLF, or indeed the amounts of money initially injected immediately and largely recovered. In fact, I think now completely recovered by the state of Trinidad and Tobago. So then what is the case about? Rather, the case concerns the failure of a Trinidad and Tobago-based financial conglomerate, CLF, which drew into insolvency its subsidiaries. Secondly, CLF has been managed as a group on the basis of a group strategy with group projects like the Green Island property purchase allocated to various subsidiaries, but directed from head office and carried out on behalf of the group. Thirdly, BAT and BICO were particularly closely managed together. They sold the same products under the same name, just in different markets. They were one economic entity, so that separation would have had to be carried out, if required, for regulatory reasons. And I'll just give you the page name check. That was a minute note 5101, which we looked at, but I won't take you back. BICO employees were paid by BAT, name check or reference check, page 5102. Fourthly, the CLF group was sunk by a mix between the financial crisis and unwise investments. Fifthly, the mismanagement occurred at CLF group level in Trinidad and Tobago, not at BICO, and certainly nowhere near the Bahamas. Finally, sixthly, the hole that the funds disappeared into was in Trinidad and Tobago, or maybe poured from Trinidad and Tobago into a large hole in the United States. But anyway, not anywhere near the Bahamas. When the financial crisis hit and alarm bells started ringing throughout the region and the world, the defendant quite understandably used its leverage over the CLF group as a domestic group to wring out of it and its many subsidiaries as many assets as possible, irrespective of whom in the group they belonged to. That was the reality. There were many reasons for doing so, one of which was to bail out the important conglomerate and not to permit panic in the ranks. One of the other reasons was because, of course, the government had itself invested so much capital through very many of its institutions into that group, and had, for example, the bank failed, so would they have struggled to get back those funds. So there were many reasons why they did so, and they did it, however, without question, as had been confirmed by the witness yesterday, very much with commerciality in mind, in order to make sure that they got payment back with interest payments, which they have done. So while there may have been threats by them of regulatory action, which is not the same thing as this being a regulatory case, Trinidad and Tobago didn't do it by regulatory action, but by forcing essentially commercial transactions and concessions on CLF. First and foremost, the MOU. Now, we didn't actually look at the MOU, and I'm loath to start introducing documents now because I've got a lot of speech to get through, and I don't want to hold myself back.
And neither do I want to hold you back.
And I want to crack on too. Can I
Yes,
some
but
state-
I feel constrained to ask. I've been following very carefully what you have said.
Thank you.
Whether you are going to indicate to us the specific treaty right in the RTC which you claim that the defendants have breached, such as to justify the grant of the remedies that you seek.
I've got a lot more to say. It's all coming. I'm just at the introductory level, so I will be coming to all of those submissions in due course.
Okay, and I'm happy for that, because so far I must say that the points you have made are very fascinating, but I'm afraid for my part, I have not yet been able to locate where in the treaty you're basing your case.
Well, I will make it clear as I go through.
Very well.
If you bear with me, and if I don't, then of course I will very happily try and clarify, but I hope that all things will become clear.
Wonderful.
Thank you. And without
Sorry.
taking, not at all, without taking any more time, I just ask you
So,
to be.
Counsel,
I'm so sorry.
if I may, you are constantly referring to the group as though it were a single economic entity. What is the basis of that? Aren't these separate companies?
Well, on paper, they would have been, and of course there are ways of behaving as separate companies.
But
but
how do you get to that? How do you get past the corporate veil which surround each and every one of these companies?
Because you can easily pierce the corporate veil here.
Yeah, but pierce it on what basis? What is the principle? And you haven't evinced any principle which would help certainly me in understanding why you are liberally grouping these companies together.
I think in essence, but I will deal with all these points, I hope, in turn. In essence, the behavior of the individual entities within the group completely blurred the differences between the relevant entities. And there was a behavior right across all of those entities, which basically deliberately confuse the boundaries between entities operating individually and operating with their assets individually.
So are you suggesting that
And with their administration.
this is a principle on which this court should, as you call it, pierce the corporate veil?
Well, the corporate veil piercing principles are pretty well known, and they're going to be triggered in an instance like this. The court, any court, common law court, will look to see how companies behave. They will look to form, not the substance, and that's a factual exercise.
Yeah, this is not my understanding, but I'll allow you to develop the point as you go on. But I must confess that I'm intrigued at how you switch from CLF to BICO to BAT and so on, when these are separate entities. It doesn't matter who owns what. The fact that BICO owns the majority shares in BAT is neither here nor there. They're separate entities.
Well, but as I will develop, because of the way that they behaved and the way that they acted, everything starts from the facts upwards. And any case of piercing a corporate veil is essentially primarily a factual exercise.
Yeah, but it's a factual exercise to which principles are applied.
Yes.
Anyhow, don't let's be,
I thank you very much for
yeah.
flagging it up. I hope that I will be able to deal with it satisfactorily as I go forward. But
Yeah,
it's
thank you
very
very much.
helpful.
Thank you.
So I'm sorry to labour with the facts. I just would merely like you to be aware at the right time of the width of the MOU, which is at 5040. I'm not going to look at it now. I just want to draw to your attention the language of that, which is both inclusive. It identifies CLICO and it identifies CIB. But it does use words such as its affiliates to include colonial life, etc. So there's very much inclusive language. It also, at paragraph 6C and 11C, specifically deals with a roving power to reach into other assets of the CLF group of companies. Now, the CLF group of companies includes BICO. And so the contract reaches right across what might have been defined as a CLF group structure and it literally goes into every aspect of each of these companies' assets and attributes. Specifically with CLF at paragraph 6C and with 11C reaching into CLICO and BA. So CIB at 6C and CLICO and BA at 11C. Again, other assets of the CLF group of companies of such quality and value as agreed to by the court, by the government, and as may be required. So I just want you to be aware of that. I'll return to my speech, if I may, and I'm very cognizant of the points that you have both raised, and I hope that we'll be able to deal with all matters of, there is a lot of legal substance to have to deal with here. So I'll come to that. So within the CLF group, funds of different group companies had been intermingled, fact, even before the crisis hit. BICO policy contributions had been systematically transferred to Trinidad, and BICO assets were routinely held on the books of other group companies. The CLF group did not distinguish between group companies other than when absolutely necessary. When the crisis hit, intense pressure was put on the CLF group to come up with assets if it wanted to be kept afloat by Trinidad and Tobago, irrespective of where those assets came from. The various statutory funds are really not relevant in this case, other than showing, firstly, that there was similarly lax enforcement of the prudential rules across jurisdictions, vide the Trinidad $285 million shortfall, and secondly, that Trinidad used that shortfall as one pressure point which even expressly prompted BICO assets to be offered to bring BAT's statutory fund up to scratch. And that it is dealt with in the evidence of the defendant's witness at her exhibit tab 41. Incidentally, while we're still on statutory funds...
Just a minute, Mr.
Your Honour.
Davenport. You said the MOU is at page what?
I didn't give you the page number, actually. It's
I
just
thought
an
you said
exhibit.
504.
41. It was exhibit 41 of Suzette Lee Chee's witness statement. Sorry, I can get you the page number. I just don't know it off the top of my head.
Okay. Exhibit 41.
Incidentally, as I was saying, while we're on the statutory funds, and we were being reminded all the time by the defendant that BICO could have called on insurance business in Trinidad and Tobago, as that would have been contrary to the Insurance Act. Yet lots of things happened that plainly were contrary to the Insurance Act, not least underwriting not backed by adequate statutory funds. As I have said, this is not a regulatory case, and the court certainly does not have to investigate whether what BICO was doing in Trinidad and Tobago was in breach of the Insurance Act. But this is not a situation where it can be assumed that because the Insurance Act did not foresee something, that means it didn't happen. What we have been generally terming was being termed the bailout, but it's really a debt restructuring exercise with acquisition of assets within it, because that's what the government did, was first and foremost a commercial exercise. As I said, they were determined to, and did, get back every dollar that they put in. And that is what they did. So it was prudential movement on a political front. It was good economic management, I readily accept, but it was backed by commercial choice and execution. So it wasn't a bailout in any traditional sense, but in the sense that I've just defined. What the claimants are, though, reproaching the defendants for is that in the course of taking control of CLF Group, Trinidad and Tobago acted inconsistently towards, or with regard to, BICO and its policyholders in two particular ways. Trinidad and Tobago was happy to take into the common CLF Group pot all of the BICO assets, many of which have been intermingled with CLF, CLICO and BAT assets, and this is the fundamental factual question. already before the crisis hit. So that was the factual matrix that I invite you to find. But Trinidad and Tobago refused to use that pot. So the pot was fed, but the pot did not pay out the CLF's group's obligations towards BICO and its policyholders.
So that is a case you are putting forward,
Yes,
which may be disputed by the other side, possibly. yeah?
it may be, but
It may be,
we're
but-
just suggesting that the facts really point one way to that.
Yes, I understand.
Yeah, thank you. In other words, BICO's assets were treated as belonging to the group, but their liabilities were not treated as belonging to the group and being BICO's only.
Treated by whom? By
the government.
by CLF, or because remember the MOU to which you refer
Yep.
is a agreement between CLF and the defendant, isn't it?
It is actually, that's my point about the words inclusion. I've got it in front of me. The relevant parties are the Minister of Finance acting for the government on the one part, CLF acting for itself and as agent for its affiliates to include CLICO and CIB.
That's quite correct.
No, so on an interpretational basis, it isn't nice and clear and bilateral or trilateral. It's actually importing contractually all of its affiliates. So not only its own structures, but also all of its affiliates.
The obligations are given by CLF.
Well, the obligations are given by CIB, CLICO, and BA, really, because they're the ones that, and CLF, of course, underpinning it, because they control CLICO, and BA, of course, is owned by BICO. So they overreach BICO's ownership of BAT to actually obligate BAT to divest itself of its assets and to shift around. So actually, the simple answer is, at all times, not only the group, I'm not bringing a case against the group, the group, but also the government were treating as the common pot, everything that could be taken out, and they forced BICO's assets. I mean, BAT is a BICO asset. And so they forced all of these assets to be reorganized for the purposes of underpinning the contractual bargain that's been reached between the government and the group in its widest possible sense, including BICO.
Who signs the MOU?
Thank you for that. It's a good question. Karen Nunes Teixeira.
For the defendant. She was Minister of Finance.
For the government.
Yes.
And Lawrence Dupre for CLF.
CLF.
Yeah, he was the chairman of CLF.
That's quite correct. And I suspect that these were the parties to the MOU.
Well, the parties are as defined. The signature is just the recognition of those parties. I mean, actually, since we're talking about separation of powers in a corporate structural sense, there isn't any signatory to CIB or BAT. So BAT has been signed for by Lawrence Dupre. So, I mean, it's a soup. And the participation is, I mean, this is a corporate veil. I don't think that a chancery court would have a difficulty about reaching in, because it would very rapidly come to the conclusion that these were, that everybody, government included, just ignored the divisions and the boundaries.
Okay, you can move on. Thank you.
Thank you. Could I just say, as development of what I wanted to say anyway, that at some other time, please have awareness of the shareholders agreement, because the shareholders agreement is also interesting in its language. The signatories to the shareholders agreement, and that's at page 5072, are CLF, the government, the directors of CLF, majority shareholders of CLF. But that goes even wider in terms of its inclusive nature. At recitals A and B, I draw your attention to it, and they recite faithfully the inclusive language, reaching back and referring to the MOU, but they go further, and they say, recording that CLF is a holding body corporate, so it describes a holding body, which is holding, of course, the other assets, which holds interest in various subsidiary companies, and which includes, without limitation, 100% shareholding in CLECO and CIB and 82% shareholding in BA. And that is interesting because they're saying that they own 82% of BAT. They don't own 82% of BAT other than through BICO. Okay, well, thank you. In legal terms, that's the definition of discrimination. It's prohibited as a matter of fundamental principle by Article 7, and that's what the first and second claims in this case relate to. So as to those first and second claims in Article 7, the first claim proceeds on the basis that, by reason of the factual background, BICO was in a comparable position to other CLF group companies, such as BAT. On that hypothesis, it was right that Trinidad and Tobago caused CLF to put BICO assets in the common CLF group pot. But it then follows that the common pot should have been used to pay out BICO's liabilities. The ideal remedy here would be, in effect, an obligation to put BICO policyholders on an equal footing with BAT policyholders, in the alternative to award damages in lieu, and that's our relief. The second claim is, in effect, in the alternative to the first claim. It arises if the court finds that BICO was, contrary to our primary submissions, not in a comparable, and that's the right word, position to other CLF group companies, such as BAT in particular. On that hypothesis, very much against our primary submissions, it would follow that TNT refused to pay BICO liabilities out of the common CLF group pot. But in that case, were that to be the case, BICO assets should not have been placed in the common CLF group pot. So they can't have it both ways. And those assets, including those that had been intermingled with CLF group assets before the crisis, should have been segregated to be available to meet BICO's liabilities.
Mr. Davenport, just one matter of clarification. This court has said on more than one occasion that Article 7 is not standalone.
I'll be coming to that.
You are not trying to convince us otherwise.
Yes, I am.
Oh, you are?
I am, directly, squarely. That was an obiter statement in the case of Douglas. In particular, Douglas is the sort of apex of that argument. When properly analysed, A, was obiter, and B, you should revisit it. And I'm very conscious of the fact that at least two members of this board were on Douglas. But it is something that we do challenge. It is something you should look at again, with this time a proper reference to other authorities from like treaties. And I think that you'll comfortably find that you will be able to say that that was obiter and that you should take a different path.
Yeah.
In fact, what we say
just so I can say, despite the word in itself of Article 7,
yes,
and despite what may be a different wording elsewhere, you
Yep.
still say, okay,
well,
interested to hear.
but we don't think so. When it comes to submissions,
Of course.
I mean, these are submissions. We fervently believe they're correct. Of course, you have the luxury of determining on that. But we're here, amongst other things, I'm here to one of the collateral, I hope, benefits is this is an important case, giving you the opportunity to revisit important rights and redefine them in the light of as much learning as we can bring to it. And I'm very greatly privileged to have a out-and-out treaty lawyer in Carsten Zatchler, SC, who, if we need to hear from him, we will later. But the short point is that we will be taking it on and showing you important authorities like Phil Collins' case and asking you to review that. And in fact, as to the language, we don't see any discernible language differences. I'll be coming to that as well.
We look forward.
Thank you. Unfortunately, it's a bit like wanting the favorite sweet at a particular time. I've got to deal with some of the other stuff as well. So forgive me if I'm ponderous. So I mean, it's keeping it to the sweet idiom. Whichever way you look at it, Trinidad and Tobago should not be allowed to have its cake and eat it. Trinidad and Tobago should not be permitted to deprive BICO of its assets without meeting its liabilities. Turning to a new topic, the revised treaty covers cross-border investment and financial services in its scope. It is uncontroversial that the cross-border economic activity constituted by investment of capital, as well as the cross-border provision and purchase of financial services, that is, the activities of BICO and the claimants are within the scope of application of the treaty. The circumstances that the acts have been held to be excluded from the operation of Chapter 3 doesn't change that. The self-standing nature of Article 7, which we've just adverted to, it is contained in Chapter 1 of the treaty, entitled Principles. It lays down a prohibition of discrimination on grounds of nationality as a general principle. That principle applies throughout the scope of application of the treaty. This general principle is at the heart of the treaty's aim of establishing a fully integrated and liberalized internal market, and echoes the principle of equality before the law enunciated in Article 5 of the Charter of Civil Society, which of course was adopted by the Conference of Heads of Government in February of 1997. And it echoes the principle of equality before the law, and it was recalled in the final recital of the preamble to the treaty. Indeed, the prohibition of discrimination on grounds of nationality can be seen as both the foundation of the treaty as well as its, in our submission, central object and purpose. That general principle, moreover, gives rise to rights which are independent of the operation of other, rather more specific provisions of the treaty. We've explained in detail of our written submissions, and that, Mr. President, is at page 9711, paragraphs 20 to 23, that it is irrelevant for these purposes whether or not the specific provisions of Chapter 3 operate to also protect a business activity. Article 30 of the treaty does not exclude Article 7, which is not in Chapter 3. Derogations from general principles must be interpreted restrictively, for which there is a lot of authority. That is all the more true, considering the fundamental nature of the principle of non-discrimination on the basis of nationality. This approach is comforted by European Court of Justice case law, as set out in detail in the written submissions that we've given you at page 9712, at paragraphs 25 to 29, in relation to the cases of Phil Collins and Data Delecta, I think also a Todd's case, all of which, please take note, predate the revised Treaty of Chequeramas. The ECJ has found the equivalent provisions in the EU's treaty framework to lay down a general prohibition of discrimination on grounds of nationality, which applies whenever there is an impact on cross-border economic activity. Phil Collins, that case, which I'm not going to look up now, but we quoted it extensively, and I'll read a couple of paragraphs from it. You will find it at page 10,770 of the bundle. In Phil Collins, the question arose whether the general principle of non-discrimination on grounds of nationality enshrined in Article 7 of the EEC Treaty applied to copyright and related rights, notwithstanding the fact that copyright and related rights were not specifically referred to in that treaty. The European Court of Justice held, looking at the substance of the matter and identifying the economic activity and the freestanding rights of Article 7 in respect of it, held, and I'll just read out from paragraphs 27 and 28 very briefly, copyright and related rights, which by reason in particular of their effect on inter-community trade in goods and services, fall within the scope of application of the treaty, are necessarily subject to the general principle of non-discrimination laid down by the first paragraph of Article 7 of the treaty, without there being any need to connect them with the specific provisions of Articles 30, 36, 59, and 66 of the treaty. Accordingly, it should be stated in reply to the question put to the court that copyright and related rights fall within the scope of application of the treaty within the meaning of the first paragraph of Article 7. The general principle of non-discrimination laid down by that article therefore applies to those rights. And the Data Delecta case, which is at 10,787, the question arose whether the same general principle applied to a national rule requiring security for the costs of judicial proceedings from non-nationals only. The European Court of Justice held, paragraph 15 of that judgment, a rule of domestic civil procedure such as the one at issue in the main proceedings, falls within the scope of the treaty within the meaning of the first paragraph of Article 7. It had actually been then renumbered Article 6, and is subject to the general principle of non-discrimination laid down by that article insofar as it has an effect, even though indirect, on trade in goods and services between member states. The defendants attempt to distinguish these cases as it is clear, quote unquote, that at the time of the bailout, no investment in financial services were being provided or received, is without merit. That's just simply not the case. As we've already pointed out in our many submissions and the ones in reply, there's no need for the economic activity to continue to the time a claim is brought. Once economic activity was carried out under the revised treaty, the protection of the treaty is triggered. And there are other cases which have been referred to for Attila, which by my learned friends, not of any assistance. It concerned a case where the claimants did not fall within the scope of the TFEU by virtue of not having exercised any relevant cross-border activity, whereas this case inevitably involves, undoubtedly involves, cross-border economic activity. The claimants in Rebuttal were economically inactive and had no EU right of residence in the UK, which is why they sought to rely on a right of residence under UK law and which to found their claim, which was, however, not enough to bring them within the scope of the law.
Can we pause here for a moment, just to make sure I'm following you, because I want to make sure I'm following. You are saying that notwithstanding the points raised by my brother about separate legal entities, notwithstanding the issue of separate regulatory environments, including central banks exercising regulation over insurance companies. Notwithstanding all of that, your position is that the government of Trinidad and Tobago brought into a common pool the resources of your company, BICO, and therefore in exercising the bailout activity, it ought to have done so on a non-discriminatory basis. Am I leaving anything out?
No, very, very good. I mean, the only thing as to regulatory, we say that that's a red herring. It's got nothing to do with regulatory proceedings. This is not a regulated proceeding, so that goes. So that's really back to the point about whether or not there's some magic in the formality of completely ignored corporate structure. And the answer is in the facts, because the corporate structure is ignored, not only historically by the corporate structure itself, but subsequently by the government. Or another way of putting it is actually they're just included, is that they haven't followed, the government hasn't followed through the consequences of their own actions. And what they've actually done, when one looks at the documents, the MOU and the shareholders agreement and the facts, is what they've ended up doing is actually including, whether they intended to or not, it doesn't really matter. They've included BICO because they basically dealt with BICO as if it's included. Certainly, a contract lawyer, I hope, would agree with that, looking at the MOU and shareholders agreement.
And based on the summary to which you have agreed,
Yep.
you're further saying that there is no need for us to locate a particular right in the revised treaty, that the facts that you have established in your arguments are sufficient in and of themselves to allow for a remedy to be given to your client.
First of all, I apologize for cutting across.
No,
I
that's
really
fine.
do. Yes, insofar as it relates to principally the first and second arguments that we have, but in respect of our third argument, of course, we then very much attach it to the 184 article, and so that does, as it were, have a parent article to attach to, or another article to attach to. That's my third argument. There is a fourth argument, which is the right created by the $100 million promise, which I'll come to in due course as well.
Okay, so the first two are not dependent on any specific provision in the treaty giving a right, but the
It's Article
third,
7.
184,
Right, it's Article 7 itself.
Article 7, subject to what my sister asked you about whether it's a standalone provision or not.
Yeah.
Yes. But the third one, you can locate a provision. And then there's a fourth one you mentioned, the $100 million you're going to come to.
Yes, that's a sort of separate point.
I follow you, yeah.
Thank you very much indeed.
For my own benefit, let's go over again. The first two arguments are premised squarely on Article 7.
Yep.
The third argument is what?
184 and 7.
Exactly. So that unless you can make out your claim using Article 7, the third argument would also fall away.
Well, no. The third argument is an independent, discrete argument, which doesn't fall prey, as it were, to the Douglas position, which is that Article 7 can't be a freestanding remedy.
Yeah, but in order for the third argument to be made, you need to bring in Article 7. Article 7 is a fundamental prop for the third argument.
Yes. Yeah. What I'm told by Mr. Zachner, which I agree, of course, is that Article 184 brings in and engages with Article 7.
Oh, yeah.
Right. Okay, fair enough. And then the fourth argument is about the promise of the 100 million.
Yeah.
That was pleaded in the statement of claim in the originating application.
And for which you've given permission.
Okay. Yes.
I don't recall, though, Mr. Davenport, it being part of our order when we made the preliminary determination in the first Ellis Richards. I don't recall that. I do believe that we said Article 184 and Article 7 insofar as it is applicable. So I'm a bit surprised to hear about this 100 million in this context. Anyway.
It's been pleaded for a very long time. And we've explored the facts in relation to it. There has been general permission both conceded and then, of course, we had the preliminary ruling. I suppose on my feet, I'm without being able to just check everything thoroughly, but I've got a huge team, so they can. I believe that it was. If there was going to be an objection to it being taken, because we put it in writing, long and hard, I imagine it would have been taken now, so that if I was wrong about the permission point, as late in the day as it is, I would ask for retrospective permission to be given to consider the debate that has been aired in evidence and time and effort, and is a good point. And if it's a bad point, I understand that the court might take a dim view, but were that simply to be the only stumbling block, I would ask the court to grant us the indulgence of adding that by way of its permission, however late granted. And I think the court can grant permission, as it were, at a later time.
Personally, I'm intrigued by that point, actually. And you did mention it in your pleading, but I thought it was mentioned in a very descriptive way rather than as a pleading per se. But it was mentioned as part of the background.
It was and has developed a life of its own. And this is not the time to quote English Commonwealth authorities, but the much-loved Judge Lord Denning sat in many cases, and his primary lodestone was to try and make the law fit in with what he perceived to be the just sort of outcome. There was a case called Re Van der Velde number 3, which was stood for how late you could make such an amendment where the facts have been in play. Now, I simply make the point that if the facts have been in play as they have, without interruption, because had there been interruption, we would have tried to cure the remedy, tried to cure the fault if there had been an earlier fault at its earliest possible moment. And
Mr. Can I just ask you something? How does this, on the assumption that there was this unequivocal commitment, this $100,000 US commitment or promise, how does that sound in international law in terms of cross-border rights and remedies? Because you've located 1, 2, and 3 in terms of Article 7, in terms of 1 and 2, and the conjoint effect of 184 and 7 in terms of 3, and then you said, but also the GRTT's promise to pay the US 100 million, and we've gone off on, of course, whether you can raise it. But what you have not told us in relation to number 4 is where and how do you locate that in terms of rights and remedies under the RTC?
Well, I think it's actually paragraph 55 of the case of Myrie, deals with the binding obligation of such an announcement and subsequent promulgation. It was accepted on the facts by Ms. Lee.
Sir, are you thinking of the conference decision in Trinidad Mary?
Maybe not, but in Myri at paragraph 55, it goes wider than that and talks about the nature of binding obligations. I don't have it to hand, but I know that it's in paragraph 55 of Myri because I was looking at it earlier. And the general position is that it's generally binding as obligation. It doesn't take the.
Mr. Davenport, I'm sorry, I'm not quite following. I was trying to ask you, where can this be located in terms of the RTC?
Yes. I don't
Are you
think
saying that the Myri decision is where you are locating it in the jurisprudence of the Myri? I'm just trying to be clear.
No. It's
No.
a very good question, if I'm peaceable to say.
Because we hear about, in this jurisdiction, whether or not the government made an unequivocal representation and or promise that may sound somewhere in law, we are in this court about the RTC.
Of course. Well,
So you have to,
I
in
think
some form or
Article 9
fashion,
Article 9. would
Article
be-
9.
Yeah, Article
All
9.
right. Okay.
And you say then that Article 9 is also freestanding, is that right?
Well, yes, we do.
There's a lot of freestanding articles in the RTC, Mr. Davenport. But you will concede, though, that your ability to prosecute that fourth round is dependent on some kind of leave, some application, some allowance being given by the court.
Yes.
Yes. Okay.
I would. Yeah, thank you. But it's why wouldn't the court? It's a binding obligation. This is an international court. The route to national remedies was deprived from our clients. And so here we are dealing with this subject matter. If it's an obligation that's binding, this court should exercise jurisdiction to carry it through. Think I was at talking about Douglas. The consideration in Douglas to the effect that Article 7 of the treaty was not a standalone provision is obiter, as I said, is precisely in circumstances such as the present case, where more specific provisions do not operate, that Article 7 must develop its effects to protect economic activity between member states of the community, just as it did in that whole series of EU cases that I've referred to, and that we have put in our written closing submissions and reply. That issue didn't arise in Douglas, which consequently didn't decide that particular point. Can I just remind you, when you look at Douglas, that Douglas was a national of the respondent. Hence, he could not derive rights from the treaty against his own state. That's an important point to bear in mind when you look at the case of Douglas. The principle of non-discrimination, because we're saying the defendant's intervention was discriminatory on the ground of nationality, that's the first claim. The principle of non-discrimination on the basis of nationality enshrined in Article 7 requires that comparable situations must not be treated differently, and that different situations must not be treated in the same way, unless such treatment is objectively justified. There's one distinction in the wording between Article 7 and the equivalent in European treaties, in that it concerns discrimination on the basis of nationality only. Neither we nor the defendant have been able to attach concrete significance to that word in the context of the present case, and it ultimately appears to be a distinction without a difference. Now, difference in treatment, we would say it's uncontroversial that there was a difference in treatment, consciously so it appears, in the present case, in that Trinidad and Tobago caused CLF to put BICO assets in the common CLF group pot, but did not permit that common pot to be used to also pay for BICO liabilities, as I've said.
Could I just explore that with you for a moment? Because I'm trying to follow you. You're saying that the inclusion of the word only in Article 7 is an effort without a difference. It doesn't make any difference at all. Okay. So I gather that in
the present context.
I gather that in the case we are concerned with, Trinidad and Tobago paid to a number of policyholders who are not
13 out of 27.
who are not Trinidadian nationals, bailout in effect. Yes?
13 out of 27,629.
There was another 1,000 and something. Who were they paid from? Were they not also?
I don't think so. I don't think those are the facts. I think the facts, which are actually stated by Ms. Suzette Lee Chi in her witness statement, identify 13 out of 27,600 odd.
Of BAT, but in terms of the CLICO, wasn't there a payment out of 1 billion TT dollars in respect of 1,072 EFPA policyholders?
From the cheap seats, it's certainly,
This doesn't matter whether it's 13 or 13.
I'll take some instructions on that. I'm taking.
Well, assuming that that is the case for the time being. So if you were representing one of those 1,072 policyholders, or 13 in the case of BAT, and they were not paid the bailout as their Trinidadian counterparts were, would you not be able to say that they were discriminated against on the basis of nationality only? Because the policies would have been issued by the same company, they would have been subjected to the same regulatory environment. The central bank would have had supervisory jurisdiction over them. And therefore, the only difference between the Trinidadians being paid and these 1,072 plus 13 others not being paid would have been nationality only. Would you not agree?
No, I think with respect, we don't agree because it's a question of relevance and relevant context. I mean, that's not the relevant context. It's the relevance is only BICO nationality, not, as it were, that hypothetical, that situation.
Well, it's not hypothetical. I mean, these are people who were not
hypothetical. If I was taking the action on behalf of those people who had.
Oh, I see. That would be
Yeah.
that would be hypothetical. But in that scenario, you would agree that the only difference would be nationality, wouldn't you?
Sorry, if I just take a moment,
Sure.
I'll refer to my colleague. I mean, for the moment, we're sticking with the idea that in the context of the present case, it makes no difference.
Makes no difference.
Yeah.
Okay, but all right, let's look at it from a different angle. If you are representing, as you are now, the policyholders of ICO,
Yes.
and they got their policies from a different company. Now, I know you had an exchange with my brother about the fact that they're commingling, etc. But legally, they got their policy from a different company. Agreed?
Yes.
Okay. They were subject to a different regulatory environment. They were subject to different judicial management arrangements. So would you say that the difference is nationality only, or are there other extraneous factors which would differentiate this category of policyholders from the others that I spoke about earlier, the 1,072 and the 13?
Yeah, I'm going to confer on that. Okay. We say the regulatory environment is not the relevant distinguishing factor, but they, in that instance, would have got their only policy, or the BICO policyholders, from a legally different country. That's the only distinguishing feature. Yeah. Yes. nationals. And that is the difference in nationality we're relying on. At some point, and one of the reasons why Mr. Zatcher is standing next to me is that my knowledge is not as good as his about treaty law. And if it gets deeper than that, then I will ask Mr. Zatcher just to address the court.
Sure.
Sure. No, that's fine.
Tell me something. Does Article 7 import, in order for it to be effective, some form of mental element in the discrimination? And if so, how would one describe that mental element?
No, we don't think it's the subjectivity in it. We think that it's an objective test, as things seem.
So one simply looks at the behavior, irrespective of the motive of the particular.
Well, we were just debating that behind the scenes. That would make it worse. I suppose that would become a factor. I mean, at the end of the day, all elements could be potentially interesting factors. So I'm not here to say that it's closed, but the court is going to look at the objective elements first. If it's in a position to satisfactorily determine what the intentions were, then I could see that might become potentially interesting. I mean, I did debate with the witness in cross-examination whether or not actually how we've come to this pass, and whether or not there had been any intention to do this. It looks to me, if you look at the press media releases, when he's talking about wanting to contain a contagion, like almost like talking like a virus that is spreading out from Trinidad into the region, and that it was a region-wide problem. And the points that I did cross-examine on in respect of the contemplated inclusion by the Prime Minister when referring even those many years later to the Coleman report, even then, was it very, very clear? What we have put before you is there's this one sentence in the transcript in Parliament where the Prime Minister makes a reference to "in this country," and that was in June 2009. Now, I would be surprised if it really was thought through that carefully, that at June 2009 there had been a decision to actively exclude. What I wanted to be able to show you, but I don't think I can factually, is where was the definitive tape-cutting moment whereby somebody said, no, I'm sorry, those are not being included. This has all been interpretative later on. And it's only because there have been the unanswered correspondence, and it's woefully unanswered pre-action correspondence. And we've ended up in a position whereby we've had to take the action. But one of the points you might want to contemplate is, what was the purpose for making the $100 million offer in the first place? As a fact, I mean, it performs on two levels, not only the freestanding argument, but it's also evidence of, as it were, the intent that you asked me about, Mr. President. It may become interesting. I mean, if the court can define that it's there, then I think that it might become interesting. I'm just wanting to, I think, reflect that one would start, I think, from objectivity.
Mr. Davenport, I thought, however, Mr. Davenport, that Mrs. Leachy's undisputed evidence was that in the records and the books that she had, she could not find any point in which they were included and then not included. I got that impression from her.
Yeah.
How are we to look for anything else, if that is what you're suggesting?
Well, I think at the end of the day, it probably doesn't matter too much. I mean, that's probably where I'm going to address you on, because I think that what does it matter? I mean, if one answers oneself the question, yes, they did. They really intended to make it clear from the outset, and well, it's not very clear, but that's what their position is now. There was a right, in which case there was a breach of it at the time. And it's not been clear in their evidence either that there was a firm line in the sand. So the only person they've chosen to call, not somebody from the central bank, not somebody who had been a relevant minister at the time, the only person that they've chosen to call isn't in a position to say when, if at all, the government ever decided to say no to the non-Trinidadian nationals.
But we may have to,
Sorry.
we may have to agree to disagree on that one because she's a permanent secretary.
Yes.
And she has all the books and records, so
Yes, I mean,
but
I was
you,
right-
you can pass on though, because your
I was
time
rightly
is going.
criticised
and-
by the Honourable Mr. Justice Jamadar yesterday, for which I apologise immediately.
No,
and
no,
also
that's,
later.
I think we've passed that, Mr. Davenport. What I wanted to, just to stay on the point of intentionality. You see, I think there is something here that I could benefit from with your reflections. The state's position is that its intent was to rescue the state. That's what the state's case is. State's case is that there was an economic crisis that impacted the economy of the state. And so what it did was motivated by that rescue, primarily of the economic condition that the state was facing. Is that an accurate summary of what the state's...
Well,
I know you may not agree, but I'm just asking, is that an accurate representation of what the state has advanced, what Ms. Leachy advanced?
I think by the end of her evidence, the answer is no, it had widened because she accepted and advanced that part of the intention also was a commercial imperative. I don't think...
But commercial from what perspective? Commercial in terms of rescuing the state or commercial in terms of bailing out policyholders?
A parallel track. It was put to her that there was decision making. They didn't have to. They could have just let the conglomerate go. So it wasn't the rescue of the nation. I'm not here to say it wasn't highly important. And clearly they took a decision, which I'm not here to criticize at all, which is that there had to be intervention. But
All right,
that
so
wasn't
okay,
the
so,
only intention.
No, fair enough. So that
My
we
point.
can have multiple motivation.
Yes.
Right, all right.
Yeah.
So is it then that in your case, and Ms. Leachy unequivocally accepted at the very end of her cross-examination your suggestion to her that there was a promise to pay
Yes.
to compensate policyholders in the OECS, I believe it was?
Yes.
Yes. So is it then your case that when you look at intention, one intent was the state, one intent is what you've just described as commercial vis-a-vis CLICO and maybe CLF,
Yes.
and one intent, you say also, based on this 100,000 US evidence, is to rescue policyholders in the OECS.
Yeah. Okay. Sorry.
No, yeah, I know you want, but I'm just trying to bring that back to Article 7.
Yeah. I've got a few things to say, if I
Yeah.
may. I think a governing point, and we failed to get this across in our Article 30 submissions. We said it, but we didn't win it, as it were. Is that the starting point is the claimants, not the defendants. You have to look at the context of the rights from the perspective of the rights holders, not the state's position.
No, I know. Oh, yes. So, okay. So the claimant's right
Not the
is not
state's
to be
intention.
discriminated against. The claimant's right is not to be discriminated. That's your Article 7 standalone. The claimants ought not to be discriminated against.
Because the
But-
starting point is there. I mean, what I'm also reminded of by Mr. Zatchler is that in EU, in pay discrimination, so gender equality cases, intention doesn't matter. The only question that arises is, were women paid less? And that's the point.
Well, that's your objective test, right? That's your,
Yeah.
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 Okay.
Yes. The only thing I wanted to say, and I was halfway through an apology, but it was going on to say that not here to give Ms. Leachy a particularly hard time. I'm here to try and protect the rights of the claimants. But there was if you read the witness statement, it reads like somebody who is very, very on top of the subject matter, whereas I'm afraid to say that wasn't the impression that had been conveyed. Now, maybe it's possible to lose that type of knowledge but the witness statement isn't written in a way that would suggest that that sort of knowledge is losable. She did concede very fairly that it was a collaborative effort in making that statement, and that's not surprising. And she very much came after the event and was trying to have access to the records and put together, as it were, an account. One of the other things you might contemplate, and again, there's no real criticism about this, it's just an observation, is that if you look at the defense and you look at the witness statements, they are a simulacrum. In some cases, they literally are. With the concession that there was collaboration in doing it, the overwhelming feeling is that it's a position, and indeed a witness statement, that was derived from lawyer input looking at documents some years later. But the short point is nobody can actually give you the answer as to when normally there's no difficulty about saying that something is deliberate. But in this case, we don't even know if it was accidental, by a side wind, deliberate, or a later position that has developed. I suspect it's a later position that has developed, because the language of all the documents that we've shown you really does look like, although they use the word CLF and they use the word CLICO, they also use the word region, and they also use the word affiliates, and they use the word group. And when you look at the actions that are actually happening at the same time, there's no differentiation between the assets outside and inside of that particular cohort. So nobody, this is all after the event, ratiocination for trying to work out who was doing what and why. I don't doubt that the imperative was a financial rescue, but not at the state's cost and not at an irrecoverable cost. What they wanted to make sure was that any money that was going to be put in was recovered, and it was recovered on a commercial basis with a pretty decent interest rate, which far outstripped the worldwide interest rates at the time. Not that CLF were in any position whatsoever to negotiate. And that is the reality of the matter. They never needed any of the regulatory machinery because there was, the highway or the hard way. And CLF were wise enough to fall into line. They really didn't have any option.
Mr. Davenport,
yeah.
I think you better get on to your points 3 and 4, because we'll give you up until 11 o'clock.
Yes. Okay. All right. Thank you. I had a speaking note, and I don't want to, start handing up a speaking note that then isn't something that I spoke. It is a development, and my learned friend hasn't got it, but I could, of course, make sure she does. So I'm in your hands about that. But obviously, there are other points that I could have articulated, although it's fair to say that they do arise out of our written submissions that have already been said. And we sort of take issue with some of the TFEU cases. The second claim, I don't think I started to introduce it. This is the assets being put into the pot. And I have dealt with that, the de facto deprivation of BICO and its policyholders' property rights. I'm asked to just identify 66 to you in my note. So on the second claim, can I just ask you to take note of this submission? It's triggered. So this claim concerns, in effect, the other side of the same coin as the first claim in terms of discrimination, as well as an interference in the claimant's property rights. It's triggered if the court finds that BICO was, contrary to our primary submissions, not in a comparable position. And as to comparability, look at the Florida court decision, look at the KPMG judgment. It's got all the factors, frankly, in there. And some of those were conceded and are reflected by the board minute notes. So the primary submission, not in a comparable position, it's our first argument. Second argument, if it's not somehow in a comparable position to other CLF group companies, such as BAT in particular, on that hypothesis, it was right that Trinidad and Tobago refused to pay BICO liabilities out of the common pot, but BICO assets shouldn't thereby have been placed into the common pot. It wasn't just assets in the sense of the active assets, but also the potent assets. And there was a claim known very well to Malone and Friend, as it happens, but there was a claim that was, I think with interest, was being circulated at 50 million. It was a $39.5 million US dollar, I think, loan. And in fact, it came before Mr. Justice Abu on a summary judgment application, and he indicated that he was going to grant summary judgment in favour of the claimant BICO against its parent company CLF, and an adjournment nonetheless was required, and essentially pressure was brought to bear internally and externally, clearly from the government. There is a page reference, I think from memory, it's 94.
Yeah, you see, Mr. Davenport, I appreciate very much what you're saying, but the president did urge you to go to
Yes, he did.
points 3 and 4. And before you do that, though, I just wanted to remind you of the conditions that are necessary to be established before relief is available. And those conditions are in Article 222 of the revised treaty. And one of the main ones is that the court must determine that the treaty intended a particular right or benefit to your client. And then secondly, there was a prejudice in the enjoyment of that right or benefit. So when you say that these rights are at large, in a sense, I have a difficulty reconciling that with the requirements that one be able to point to a specific...
Well, I think everybody agrees, and I think CARICOM agreed, that these are correlative rights, and that they arise out of the right to insurance services, and they are, as it were, bilateral and two-way rights. Yeah.
Okay, so you are saying that there is a right, and the right you're pointing to is the receipt of insurance services.
Yes.
Is that it?
Under the broad banner economic activity, which back to that Phil Collins case, that was the reason why the Article 7 point was said, once you're in economic activity, you're there, because it's a discernible right. In fact, in copyright, there was something called moral rights. I didn't even know there was such a thing, but there were moral rights as well as economic rights. And those were defined, and that was the reason why Article 7 was triggered on both of those reasons. But it was, for our present purposes, economic activity.
If you're saying that your clients were entitled to financial or insurance services, and that right was infringed, then I follow you completely.
Otherwise, you don't have a cross-border treaty. What's the point of having a CARICOM treaty?
Wonderful.
You know, it's
Wonderful.
that's where we're at. You know?
Okay.
They aren't rights otherwise. Yeah, okay. I was going to say, you're quite right to remind me and steer me back to my 7.5 minutes left. The Article 3 or 4. I just wanted to say that one of the things that just to take into account was that the loan at 39.5, which is escalated to 50, was in the bag. Summary judgment had to be granted, and it was pulled, and that was basic government pressure. So there's active reasons why assets were steered away. They had been by the central bank already. You'll remember minutes of note whereby an actual asset, a land asset, had to be replaced by another, and so they didn't do it themselves. CLECO, they actually reached over into BICO, and they got BICO to give a completely separate entity their land. It's because they were treating factually, there being no differences between the company. The companies had ceased to have independent life. All right, the third claim, Article 184. Ready? Okay. Article 84(1)J requires member states to promote the interests of consumers in the community by appropriate measures that provide adequate and effective redress for consumers. Our case is that the defendant infringed that article, both on its own and read together with Article 7. The breach complained of doesn't merely relate to the failure of the defendant to take positive steps to provide for redress on a non-discriminatory basis. Rather, the breach also concerns the fact that the defendant took negative steps to exclude the policyholders of BICO from redress and specifically curtail the application of remedies that would normally have been available. This, in effect, involves not only a failure to provide redress, but actions on the part of the defendant diametrically opposed to what is required by that article and calculated to frustrate the achievement of its objective, contrary also, by the way, to Article 9. We submit that Article 9 gives concrete expression to a principle of non-regression inherent in the treaty. Progress in one of the areas covered by the treaty, once obtained, can't be undone. The defendant breached Article 184 and Article 7 in at least three ways. First, the defendant provided redress by way of the bundle of measures referred to in the originating application as the BA Rescue Plan, but limited it to its nationals. Secondly, the defendant sequestered substantially all of the assets of the CLF group for the benefit of CIB, which was transferred into the central bank, CLECO and BAT, which were bailed out or rescued, or acquired at the expense of CLF and other companies in the group, thus limiting redress available to BICO policyholders, obviously. And thirdly, the defendant artificially and retrospectively curtailed the remedies available to policyholders outside of Trinidad and Tobago by expanding the effects of the central bank's emergency powers under Article 44D of the Central Bank Act. So just slightly fleshing those out, firstly, the defendant did take action to provide redress within the meaning of Article 184 by the bundle of measures referred to as the BA Rescue Plan, see the pleading. It took control of substantially all of the CLF group assets, including BICO.
You have that substantially in your written submissions, do you?
We do, we really
Okay,
do.
so could I then ask you about the nature of the obligation in 184(1)J? Because it could be argued, as I'm sure you are aware, that this might not create liability on an individual member state. It might be a collective responsibility for member states to behave in a particular way. And that argument might gain traction from the heading of the article, which speaks about promotion of consumer interests in the community. And then, of course, Article 185 speaks about protection of consumer interests in the community. Now, going back to 184, there are many provisions there. You have quoted one of them, the provision of adequate and effective redress for consumers. But there are others, so for example, to encourage the development of independent consumer organizations. There's another one which speaks about promoting the provision of adequate information to consumers to enable the making of informed choices, I suppose that's front of label packaging, that kind of thing. Ensuring availability of adequate information programs and so on. Would you say that this represents a raft of obligations which are binding on individual member states, or is it that you're picking out just that one dealing with the redress for consumers?
But I think that some rights are more concrete than others, and it really depends on the facts. And in this particular case, the facts fit the cap and engages with it. So, I mean, I understand the question and in the round, but focusing on 184(1)J, that is most definitely a right which is concrete enough to be defined and enforced.
Okay, so you're lifting out 1J from the rest, and even though some of the rest may not be capable of producing that kind of legal stringency, you're saying that this provision is.
Yeah.
Is that it?
That's nicely said.
Okay.
Better said than I said.
Thank you.
Thank you. So on that first of the trifurcation of the breaches, as I've been rightly reminded, it's in the pleading. But those measures that demonstrated what the defendant considered to be required for the purposes of adequate and effective redress, which incidentally meets the defendant's main thrust, which is to argue that 184 is not sufficiently clear, precise, unconditional, and legally complete, as in concrete, to give rise to rights. On the facts of this case, there's simply no need to rule on the clarity and precision of Article 184(1)J in abstract terms, as the defendant has provided concrete content to what it considers adequate redress. So it's a slightly longer answer. Namely, the defendant's arrangements for applying the group's assets for meeting its liabilities while simultaneously curtailing other available remedies by the recourse to the central bank's emergency powers. The defendant, having supplied concrete content to the notion of appropriate measures in the context of the present case, the court would simply take that as its starting point and examine whether the defendant itself implemented as appropriate measures was in conformity with its obligations under the treaty, notably without discrimination on grounds of nationality. Article 7 precludes a member from discriminating on the basis of nationality, as we know, in adopting measures falling within Article 184.
Mr. Davenport.
Yeah.
Sorry.
Yeah.
There's just one little problem which is engaging my mind. Thanks to your very, very ample and sound submissions. But when I look at Article 184(2), I'm wondering whether the claimants would fall under the definition of consumer.
I'm going to come on to consumer. And so
Yes, I noted you've addressed it in your written submissions,
Yep.
but there is one aspect of it which I didn't find any discussion of.
yeah.
Would you say that the claimants here were to be supplied services or goods?
Services, I'd say.
Well, the evidence yesterday seemed to be suggesting that what they were purchasing was a financial product rather than.
It's still a service. Actually, I must say, I haven't stopped to think, but I think that's more a service.
Sorry, the annuity which they bought, was that a service?
I think financial service is a provision of financial service. It's not goods,
Wouldn't that be a shows in action?
that's still, well, that's a right, isn't it? Shows in action is an equitable right.
Quite apart from that, isn't the annuity contract more in the nature of a shows in action?
Sorry, may I could just confer for a moment? Yeah, well, I'm told that for World Trade Organization purposes, it's recognized as a service. I'm sorry, that's not a very helpful answer to you at this stage.
Well,
but I don't have any reference to that.
it doesn't help because the actual wording of 184.2 is that the consumer must be supplied with goods or services.
I think we're struggling to see the difference because it was a goods or service, and there's not a...
Sorry, yes. The reason why I'm raising the question is because of if you look at the definition section in, Article 1,
Yeah.
you'll see that goods are defined to exclude real property or shows in action.
He says it means all kinds of property other than real property, money, securities, or shows in action.
Yeah, so if
I respectfully agree with that's why it's goods or services.
that's correct, yes, but the annuities contracts.
But that would be the definition of goods. But the right attaches to goods or services. So if it's services simpliciter, then it attracts the right.
Okay, so you're saying that the claimants bought or were supplied with services?
Yes.
Okay, thank you. I'm not certain that I understand how you arrive at that, but that's one aspect of this, the application of this article, which I still remain in the, having read your submissions, I'm still in the dark as to how the claimants can be classified as consumers.
Right. Can I just deal with consumers very briefly? Our position that the protection of consumers afforded by Article 184 must be interpreted as covering the activities of juridical persons to the extent that goods or services in questions are not received for the purposes of a business carried on by them in a professional capacity, i.e. whenever the
Sorry,
juridical
Mr.
person...
Davenport,
Yeah.
I don't know about my colleagues, but I think that is excellently explained in your written submissions.
Yeah. Okay, thank you. The new thing I would say, because it's arisen out of the evidence of Laverne Frances Brown, she accepted Section 27 of the Medical Benefits Act foresees the making of investments by the Medical Benefits Board. She, on that basis, went on to say, at least in layman's language, investment services were received in the board's business. 4 points arise out of that quickly. Firstly, the very specific terms of the RTC relevant here are legally defined and therefore bear a meaning which is to a certain extent different from layman's terms. That's not unusual in legal texts. Secondly, even for legal purposes, the activities of the Medical Benefits Board have to be circumscribed in detail to avoid the board being accused of acting ultra vires. The business of the Medical Benefits Board remains the administration of medical benefits. The board doesn't carry on an investment business. Any investment made was thus not made in the course of a business carried on by the Medical Benefits Board. Third, the class of consumers protected by the treaty should teleologically be interpreted includes everyone from the individual policyholder to the representative juridical persons established under various companies and cooperative legislation, whether as credit unions, teachers' cooperatives, credit unions being everywhere here, hospital unions, and workers' associations. Indeed, many of these consumer representatives and unions are not established for profit, business, or gain, and they are the Caribbean's answer to social solidarity schemes and represent niches of consumer groupings. Just because several consumers pool their interests doesn't make them professionals, or should they lose their rights. Fourthly, finally, as a matter of general approach, a wide interpretation should be given to provisions conferring rights and a narrow interpretation to provisions limiting those rights. This approach strengthens the effectiveness of the provisions of the RTC and is in line with the principle that a contracting party should not be able to rely on an ambiguity, which is in itself at least partially responsible for the contra preferentem rule. The final submissions as to relief sought, claimants reiterate the relief sought in the pleadings. The effet utile of the treaty is safeguarded efficiently and more effectively by ensuring that the redress actually provided by a given national legal system are applied in an even-handed way than by imposing damages liability. Given a choice, domestic courts and the court itself should, so far as possible, interpret national remedies in order to achieve the result sought by the treaty and consequently comply with the general effect of Article 9 of the treaty. Alternatively, its damages in respect of the BA international assets, including claims against CLF, etc., is set out before, which the defendant caused to be misapplied to the detriment of the claimants. The remedies were wrongly curtailed by the defendant and the consequent unjust enrichment of the defendant itself. So really, those are the points. Any of the fact-attainment hummingbird case law, we have answered it from the community in our reply, and that has not been answered. If that does get answered, we'll come back to you this afternoon. We do not anticipate being very long because we have set out our position in writing in respect of the community's very helpful intervention. I'm very grateful to the time that you've all given me, and I apologize if I haven't answered every one of the questions that I was expected to do so. But these are our submissions.
Thank you. Thank you very much. Council for CARICOM, we do recognize your presence. I'm sorry that you didn't have a chance to enter your appearance, but we are seeing you on screen, and in due course, we will hear from you.
Sorry.
Okay. We take a little break and we try to come back at 11:20.
All right.
Yes, Ms. Speak.
Thank you, Your Honors. May I start by apologizing? I am suffering from the virus, so occasionally my voice goes sometimes at the most inopportune time. So I'd ask for leave to take a sip of water and maybe take a minute if necessary.
Sure.
So, Your Honors, we were tempted to say that we rely on our written submissions, which we filed on the 5th of February 2020, which you will find at page 10880. And our reply submissions to CARICOM, which you will find at 11348, and say we have nothing to add, because in our respectful submission, nothing emerged out of the cross-examination of the witnesses yesterday to breathe life into this claim, which we have contended from day one, is hopelessly without merit and should be dismissed. And as I say that, I look across, and if Justice Barrow was here, he would say, well, Mrs. Speak, why don't you sit down? But I will refrain from doing that because we think it's important to, if only to emphasize some of the points which we've made and to answer any questions that Your Honors may have, that we continue. So in the judgment of this court on the preliminary issue dated the 8th of March 2023, which you will find at page 2579, that we will call Ellis Richards number 1, this court dismissed that part of the claim, which sought to rely on Articles 36, 37, and 38, which are the rights to provide and receive services in Chapter 3 of the RTC as being non-justiciable. What was left after that ruling was an allegation by the claimants of a breach of Article 184(1)J and Article 7 of the treaty insofar as it is applicable. Now, that's an order of this court that my learned friends cannot escape from. Now, we say that with respect is a very thin thread to hang the claimant's claim on, where they are seeking to have all BACO FPA policyholders, wherever they are in the OECS, treated the same as the CLICO and BAT policyholders were treated in what has come to be known as the CLF bailout. Of the 3 affiliates of CLF who were parties to the MOU signed with court, and you will find that at page 5972, and in the agreed statement of facts, the terms of the MOU are agreed, and you will find that at page 4364, BAT was a very small player. According to the unchallenged evidence of P.S. Leachy, there were only 52,000 policyholders altogether of BAT, as compared to CLICO's 260,000. And you will find that at paragraph 20 of her witness statement at page 5472. And the focus at the beginning when CLF approached court and central bank was CIB, not CLICO, not BAT. You will find that at paragraph 37 of a witness statement at 5478. However, the focus later changed to CLICO, which turned out to be in a far worse financial state and ended up receiving the largest portion of the bailout. There was no BA rescue plan, as the claimants contend. Now, as we understand the claimant's case, the crux is that BAT and BACO effectively operated as 2 arms of one Trinidad and Tobago business. And you will see that at paragraph 7 and 8 of the re-amended originating application at pages 4605 and 4608. And you will see it in my learned friends' submissions at paragraph 56A and 57 at page 9719 and 9722. But we say, notwithstanding my learned friends' submissions, that they have failed to prove that this Trinidadian insurance company and this Bahamian insurance company, each registered to carry on insurance business in their respective jurisdictions, are 2 arms of one Trinidad and Tobago business. In fact, what the evidence shows is that BACO entered into a services agreement with a company called BA Management Services Limited as far back as 2005, which is 4 years before the MOU, under which BA Management Services, as an independent contractor, and that's in the agreement, agreed to provide financial, administrative, marketing, information technology, investment, actuarial, human resources, legal, management, and corporate services for BECO for a fee. You will see that at Exhibit SLC 64 at page 6810. And the invoices from BA Management Services Limited to BECO over the period 1st January 2006 to 1st of March 2010, so that is even after the appointment of the judicial manager, are in evidence before you at SLC 66 at pages 6839 and 6890. So what is the evidence? The evidence is that there was a commercial arrangement between BECO and BA Management Services Limited to provide those services. And as Judge Kimball said in his opinion on the recognition of foreign proceedings, which you will find at tab D to the re-amended originating application at page 5013, this is what he said. This arrangement is not unusual. BA Management is a wholly owned subsidiary of BECO, which is in turn owned almost entirely by CL Financial. Both CL Financial and BA Management are located in Trinidad. It is not surprising that CL Financial centralized all of BECO's management tasks near CL Financial's own place of business. It is also not surprising that CL Financial did not set up BECO's management hub in the Bahamas. For a significant time prior to Mr. Lopez's appointment, BECO had no tie to the Bahamas other than was absolutely necessary to maintain its corporate existence and insurance license. And he continued, the court is not troubled by the fact that BECO acted and continues to act primarily through a subsidiary. By its nature, a corporate entity must carry out its business through employees or agents. It makes no difference that the agent in this case is another corporate entity and a subsidiary of BECO, or that BA Management's employees undertake such tasks for BECO. Indeed, it appears that BA Management's sole purpose was to perform management tasks for BECO and its related entities to obtain a positive tax benefit for BECO. So that's the evidence. That's the evidence that was put to Ms. Leachy. And that conclusion of the judge was based on the evidence put to the court by the judicial manager of BECO, Mr. Lopez. At paragraph 119 of her witness statement, Ms. Leachy's evidence is, and this is uncontradicted, prior to 2009, the state had no knowledge of the manner in which BAT and or BECO arranged its internal affairs. Now that's quite understandable, we see, because these were two of many companies in the CLF group, private companies which would not have disclosed to the world how they conducted their business and what commercial arrangements they made in their own commercial interest. The minutes of BECO, which were put to Ms. Leachy in cross-examination, internal BECO documents, not public documents. So BECO had no branch in Trinidad and Tobago. It did not sell policies in Trinidad and Tobago. It was not registered to carry on insurance business in Trinidad and Tobago. So it wasn't on boards or central bank's radar at all in 2009. As Ms. Green-Thompson accepted under cross-examination, there was no directive from central bank that BAT and BECO be segregated. She saw no such document. What was on the state radar were CLECO and BAT, two companies registered to carry on insurance business in Trinidad and Tobago, the number and nature of the policyholders who were affected, and the collapse of which, particularly CLECO, would have serious repercussions for the economy of Trinidad and Tobago. It was clear from Ms. Leachy's evidence under cross-examination that there was nothing in the records of the ministry to show how BECO conducted its operations other than the BA Management Services Agreement. We can do no better than to cite the words of this court's judgment in Ellis Richards number 1 at paragraph 40. This is what the court said. Financial bailouts by governments to reduce systemic risk, avoid or mitigate a collapse of the financial system, increase stability, and reduce the likelihood and severity of recession are not uncommon internationally. For example, reference may be made to the United States and the UK's commercial bank bailouts during the 2008 global financial crisis. As counsel for the defendant pointed out, legislation was enacted to give effect to the bailout and/or significant funds injected to avoid economic collapse. In this case, the defendant's actions in bailing out CLF and its subsidiaries would appear logically to fall within the space for governmental action contemplated by Article 32 and 3 of the RTC. This is what the court continued to say. Defendants' actions were part of a decision to safeguard the economy. The RTC was meant to operationalize, facilitate, and govern free trade within a customs union. It was not intended to hamstring governmental action taken in economically turbulent times to shore up and protect the national economy from extraordinary shocks and hazards. That is this court.
Ms. Peake, okay. Would you concede that the effect, the consequence of Mr. Davenport now called it a restructuring exercise, and the judgment is called a bailout, but the effective consequence of this was that policyholders who had invested with BACO were treated in a different manner from policyholders who were affected, who had their policies with BAT.
Well, you use the word treated, Your Honor, would suggest that they were under consideration and the decision was made to differentiate them. And what we've been at pains to say and what the evidence discloses is that BACO was not under consideration
I
at all.
appreciate that. I'm not talking about a mental element now. I'm talking about the objective result.
Well, the objective result is that everyone who was excluded from the bailout was treated differently. That's objectively. But we only get to consider BACO because of the claimants bringing their case and saying BACO and BAT are to be treated as one economic enterprise operating in Trinidad and Tobago. We do have similar considerations in relation to CLICO Barbuda or any other entity that was excluded. So the court's focus, quite naturally, is on BACO. But the court's focus must be what is the case that the state has to answer. It can't be in dispute that BACO was not included. That's clear. But so was everybody other than CIB, CLICO, and BAT.
So that the basis for the exclusion was that they were not registered entities.
Well, I will come to that. That was one of the considerations. But the other is that CLF never asked government to bail out any of those other entities. And that's why you have the MOU. The MOU comes and they say CLF acting on behalf of CLICO, CIB, BAT. And there's a clause in the MOU, I think it's 17, that says they will have to produce resolutions authorizing CLF to act on their behalf. And those resolutions are in evidence before you. So when Mr. Dupree et al. Came to the government and to Central Bank, they weren't speaking about any companies other than were operating in Trinidad and Tobago. In fact, the letter of the 13th of January 2009 that's in evidence, he talked about these companies affecting the financial system of Trinidad and Tobago. And unless he had used those words with respect, government and Central Bank would not have been interested. In other words, the government's business is not to bail out private enterprise. Government's business is to shore up its economy and ensure that the system does not collapse. And it was the merging of those two factors that caused government, reluctantly I imagine, and there are many taxpayers who disagree with it, to make the intervention. And today CLF is in liquidation, put into liquidation by government because the debt has not been repaid in full.
And
those
any
are
remedy
proceedings which
you would say,
commence.
I suppose that any remedies that parties who are adversely affected by these non-Trinidadian companies could have, they were entitled to, or their judicial managers, to take action to secure whatever remedies they could, as indeed the judicial managers did in Baiko, in Florida and in other places.
Yes, and in Trinidad and Tobago, my learned friend referred to that litigation in Trinidad where CLF was sued on a promissory note for $39.5 million US dollars, and government intervened because the fear was that if judgment was entered for CLF, it would have been wound up and there would be little chance of government recovering its monies. And we ended up paying Baco $50 million under that judgment, which we assume responsibility for. So, and the evidence, I thought it was very instructive when I asked Ms. Green Thompson, the judicial manager's business is to act in the best interest of the depositors. Did they consider bringing this litigation in the Caribbean Court of Justice? No. What have they been doing? They've been going to the United States. They've been suing former directors for breach of fiduciary duty, trying to recover monies that are due to them. And those are continuing actions. So, I mean, I don't want to use, derogatory terms, but this litigation is really a stretch. And I don't fault the claimants for, making the attempt and so on. But with respect, it really has no ground at all. It has no ground. In our respectful submission, it had none at the beginning. And then following your Honor's preliminary ruling, it has even less foundation. And I think the evidence that you saw yesterday in our respectful submission demonstrates quite clearly why the claim can't stand scrutiny. And that's
Mrs. Speaker, let's just stay with the Article 7, discrimination. So your answer to the discrimination, you accept from the president that if you look at it, everybody apart from CLF, CLICO, and CIB were treated differently.
Yes.
There's no dispute in that. But you say that's not the way to look at it because the mental element is relevant, i.e., why, because this is an action against the state, why the state did what it did turned on what was brought before it.
Yes.
That is to say, CLICO's request to the state, and the state acted on that. So this was not an action by the state to bail out policyholders of CLICO annuities. Simpliciter. This is not what this was at all.
Yes.
If it were that, then it could have been arguably discriminatory. In other words, if GRTT had set about with an agenda to bail out regional policyholders of CLICO and treated some differently from others, then maybe that could have been advanced.
Well, Article 7 might have been engaged, provided that it was within
Fair
the
enough. I'm not asking you to concede
I
anything,
understand.
but you start at a different place. You say you cannot begin to even reach Article 7 because the government intervened on a request and on its independent assessment accepted that it needed to intervene to protect the national interest. And therefore discrimination does not arise.
That is correct.
Yeah.
Mr. Speaker, is it too much of a speculation to ask you if there was such a request to bail out? You brought up CLICO Barbuda, so let's use that one. Would there be an obligation on the government of Trinidad and Tobago to bail out other entities? I think that is something I was getting from Mr. Davenport as he spoke and so on.
And
I'd
I'm
like
glad you've
to-
raised that, Your Honor, because we're going to come to that. The government's offer was entirely gratuitous. There was no legal obligation in the government to accede to CLF's request. And therefore, that can give rise to legal rights. And that's demonstrated by the United Policyholders case that went to the Privy Council, where even policyholders of CLICO, who said they were the beneficiary of a promise made by the government of Trinidad and Tobago, were not able to persuade the court, either the Court of Appeal level or the Privy Council, that there was any breach of any legitimate expectation having regard to the nature of the exercise that the government had embarked on. And a fortiori, policyholders who were outside of Trinidad and Tobago could have had no expectation at all. So we reject wholeheartedly any suggestion, and we're going to come to that when we look at the reach of CLF that there would have been any obligation, legal or moral, in our respectful submission, to bail out all of CLF subsidiaries. And I don't think I don't think the Treasury could have afforded it in any event. So we turn now to Article 7. And our first position is the court has made it clear in Ellis Richards, number 1, that what the court is concerned with at this stage of the proceedings is an alleged breach of 184(1)G and Article 7 insofar as that is applicable. My learned friends in their submissions treat Article 7 as an independent ground of complaint, but we cite what the court said in Douglas, which you will find at our tab 4, paragraph 16 at 11.028. And we don't accept that this is dicta. The court was weighing in on Article 7 in the context of the case. And the court was very, very clear. And I don't think that it's a stretch. It's a natural interpretation of Article 7. It's logical, it's sensible. And I don't see, even if it was dicta, this court departing from it. This is what the court said. Article 7 is not a standalone provision, but rather was adopted to ensure that the rights inuring expressly or by necessary implication upon persons of the community were not thwarted because of discrimination on the basis of nationality. Goes on. Article 7, therefore, does not confer an inherent substantive right. How could the court be clearer? But rather provides the rule by which the framers of the treaty intended to ensure that rights granted, whether expressed or implied, were not distorted by discriminatory actions by one contracting party against the nationals of another contracting party. And former President Byron goes on. This explains why the article appears within the chapter dealing with the principles against which the remainder of the treaty is to be interpreted and understood, and that its application is restricted to the scope of application of the treaty. In our respectful submission, my learned friends cannot escape it. And in addition to Article 7 not being a standalone provision, to engage Article 7, the acts complained of must be within the scope of application of the treaty. And because Article 7, unlike Article 18 of the Treaty on the Functioning of the European Union, uses the word only, and I can't see where the framers of our treaty decided to include that word, that you can say the jurisprudence of the European Union has to be applied in the same manner. It can't. The language is different. So for Article 7 to bite, the only distinguishing factor between the complainant and the identified comparator must be nationality. Or to put it another way, in all material respects, they are similarly circumstanced, save for their nationality. And this court has made that clear in Mary number 2, which you will find at our tab 2, paragraphs 84 and 88 at pages 1078 and 10980. But the undisputed evidence is that non-national and non-resident policyholders of both CLICO and BAT benefited from the bailout. You will see this at paragraph 104 of Ms. Leachy's witness statement at 5496. So her evidence is 1,072 CLICO FPAs out of a total of 21,197 and 13 BAT step holders out of a total of 3,400. That is more than $1 billion was paid out to these non-nationals of CLICO and BAT. So there was no discrimination on the ground of nationality. The CLF bailout did not include BACO or any of its 14 branches, including on the evidence before you, Bermuda and Panama. You will find this at 9302, and that is the KPMG report, or any of BACO's subsidiaries in Barbuda, Aruba, or the British Virgin Islands, and you will find that at 9303. Why? Because those entities were not registered through insurance business in Trinidad and Tobago. They didn't threaten the collapse of the financial system in Trinidad and Tobago. And quite significantly, CLF didn't ask government to bail them out. So is government going to gratuitously come and say, well, Mr. Dupree, what about all of your other subsidiaries? What about the other branches? Why don't you ask us to bail them out too? That doesn't happen in the real world, where you have limited finances available and you're doing your best to stabilize your economy and ensure that it doesn't collapse. To the extent that the claimants in their written submission seek to invoke the alleged cross-border provision and purchase of financial services to say that they fall within the scope of the application to the treaty, respectfully submit that any claims founded on Chapter 3 rights, right of establishment, right to provide services, right to move capital, free movement of nationals, are not maintainable, having regard to this court's judgment in Ellis Richards number 1 on the effect of Article 32, and we refer you to paragraph 3 of our submissions at page 1087. Sorry, paragraph 23 of our submissions. Further, we say that even if the claimants could invoke Chapter 3 rights relating to the provision of financial services, no investment or financial services were being provided or received at the time of the bailout. A bailout is the complete opposite of the provision of investment and financial services. And to the extent that these claimants complain of the state's rescue and intervention, the onus is on them to establish that rescue and intervention somehow falls within the scope of the application of 184(1)J and Article 7 insofar as applicable, and we say that they have failed to do so. We turn now to 184(1)J. And we say, let us start by considering the language of the provision in its context. So it comes under Part 2, Consumer Protection, and under the heading, Promotion of Consumer Interest in the Community. And this is what it says. The member states, plural, shall promote the interests of consumers in the community by appropriate measures that provide adequate and effective redress for consumers. So the first point to note is that this provision is to be found in Chapter 8 of the treaty, where the concept of consumer interests is firmly situated in the context of the community's competition policy. And we draw the court's attention to Articles 169, 170, 171, 185, and 186, which all deal with the protection of the consumer in the context of anti-competitive behavior in the market. It is not permissible, we submit, to cherry-pick a general provision of the treaty on the promotion of consumer interests to seek to apply it to a situation where, in fact, the market has collapsed, imperiling the economy as a whole. So, 184(1)J is framed very broadly. Member states are required to promote the interests of consumers in the community by appropriate measures, which, among other things, provide adequate and effective redress for consumers. Now, the court in TCL and Guyana, which is claimant's tab 2, has recognized that unless specifically otherwise stated in the treaty, the obligations set out in the treaty are imposed on member states collectively. And you will find that at paragraph 65 of our submissions and paragraph 32 of the judgment at page 10020. There is no obligation under the RTC we submit that the state of Trinidad and Tobago, a single member state, has to provide adequate and effective redress for consumers across the community. Both CARICOM and the state agree that all financial institutions in member states are subject to domestic national legal requirements in order to be licensed in the jurisdictions in which they operate. Permanent Secretary Leachy gave evidence in a witness statement of the regulatory regimes existing both in Grenada and Antigua at the time, and of concrete measures taken by the Grenadian, Antiguan, and Bahavian regulators. Some of the claimants' witnesses were aware of the statutory funds in their own jurisdictions and what their object was, and they acknowledged steps being taken by their member states to assist policyholders. The judicial manager gave evidence of the plan of arrangement enacted by legislation in all states in which BACO had branches for the purpose of pooling BACO's assets and distributing them to policyholders. So we submit that these are the means of providing adequate and effective redress for consumers recognized and facilitated by domestic legislation. We submit that Article 184 lacks specificity and is not articulated in terms which are clear enough to give rise to liability on the part of member states. And we think it appears from CARICOM submissions that they share that view. The state's position is that 184.1G does not give rise to rights on the part of community nationals. Taking guidance from the EU case of Petrie, which you will find at our tab 12, page 11202, which the claimants have not challenged, the provision is not clear and unconditional, and its implementation expressly depends on the adoption of subsequent measures by a member state in the exercise of its discretion. The claimants accept, at paragraph 48 of their reply submissions, page 11288, that Article 184.1G does not give rise to a right to state aid.
A rise to what?
A rise to state aid. However, to the extent that they sidestep the provision's lack of clarity and its conditionality by suggesting that the court take the actions of the defendant as a benchmark and then work backwards to determine, and I quote, whether what the defendant itself implemented as appropriate measures was in conformity with his obligations under the RTC, notably without discrimination on grounds of nationality, end quote. And this is from their reply submissions to CARICOM at paragraphs 20 and 21 at pages 11386 and 11387. We submit that this is the antithesis of sound legal reasoning and is respectfully without legal foundation. The submission in our respectful views misses the fundamental point which the state has consistently emphasized in these proceedings. The state of Trinidad and Tobago did not render assistance to CLF when it requested assistance for its 3 identified subsidiaries pursuant to any legal obligation, whether domestic or regional. CLF had no right to a bailout. Its subsidiaries had no right to a bailout. Its policyholders had no right to a bailout. And the state, and by extension, the taxpayers of Trinidad and Tobago, had no obligation to provide a bailout. And we put before the court the Privy Council decision in United Policyholders, which you will find at SLC 59 at page 6732. And this court has recognized in Ellis number 1 at paragraph 40 that the state's actions were part of a decision to safeguard the economy. And to use the words of the court, the RTC was meant to operationalize, facilitate, and govern free trade within a customs union. That's the court speaking. It was not intended to hamstring governmental action taken in economically turbulent times to shore up and protect the national economy from extraordinary shocks and hazards. The evidence before the court is that member states took measures within their domestic economies to deal with the fallout of the CLF collapse. I refer the court to the research article by UWI's Caribbean Center for Money and Finance, which refers to steps taken by the central banks of Barbuda and the government of Guyana, and you will find this at Exhibit 89 at pages 7519 to 7524. So we ask the question, were these member states, Guyana and Barbuda, also obliged to extend their interventions community-wide? Should they too have been joined as defendants to these proceedings? Taking the claimant submissions to their logical submission, this is precisely the outcome that we would have. And respectfully, we submit that that proposition is an absurd one. We maintain our submission that it is only consumers who may invoke Article 184.1J and refer the court to paragraph 78 to 87 of our written submission at page 10905 to 10908. The claimants have not disputed the dicta we have cited from the case of QI, where the European Court, consistent with simple common sense, recognized that investors must bear certain financial risk. And the evidence of the claimants, as confirmed as under cross-examination, is that they took out policies with people knowing that the interest rates being offered were well above market. They acknowledged that there were risks to investing. and Ms. Frances Brown of the Antigua Medical Benefits Board gave evidence that the committee considered BACO's financial statements before making the investments, and that investments were made over a period of years. The evidence was that the Medical Benefits Board invested with BACO in the course of its business, and the policies were received in the normal course of the board's business. Can I just treat with the point made by Justice Burgess, which I confess took us by surprise, that, there is a view that under 184.2, it may be difficult to categorize the claimants as consumers because they do not appear to be the recipients of goods or services. And we have looked at the definition of goods, which, as Justice Burgess properly pointed out, excludes choses in action. But we have treated it, and perhaps it's something that we need to give consideration to, as the provision of insurance services. Because under the definition of policy in the Insurance Act, which we have at SLC 1, and this is at page 5528, policy means any written contract of insurance, whether contained in one or more documents, and includes annuity products. So that is why we have, without consciously focusing on the definition of good, treated the claimants as recipients of policies of insurance, even though it's very difficult to categorize them as policies of insurance. They were, in fact, investment products where BACO was saying, if you give your money and invest it with us, we will guarantee you a rate of interest, which is not really an insurance policy. But because of the definition of annuity policy under the Insurance Act, we have treated it. But I do think it's a point worthy of further consideration. I confess in the limited time available, we haven't really sorted out that.
Mrs. Speaker, memories fade after many years, but wasn't there something about the approval of the supervisor of insurance or some other entity to treating those FPA policies as insurance services? I recall something like that.
I think it was
many
argued
ago.
that is how it was treated, and that the central bank always treated those annuity policies as falling within the statutory fund, and therefore there was a requirement to have assets in the equivalent to it. But it may not be, a properly juridically sound approach, but that is the approach that the central bank took. And that is the approach that the bailout adopted. That in addition to what we call the traditional policy holders, the FPAs or the STIP holders, which were the majority of the monies invested in CLICO and BAT, would be treated as though they were insurance products and therefore benefit from the bailout. Of course, I accept that it's two different jurisdictions entirely. In other words, what we have defined in our Insurance Act has nothing to do with how the treaty is to be interpreted. And I take completely on board that when the court looks at it, it will be looking at it afresh because, of course, the court is in the business of construing the treaty and must perforce consider whether, having regard to the evidence, and you have in evidence some of the annuity contracts or the FPAs or the STIPs that the claimants had annexed to their witness statements, whether in fact that would fall within the definition of a good or service so as to qualify the claimants as consumers.
Would there be any, just not to belabor the point, but would there be anything that would cause us not to be able to open it up, having regard to our decision in the preliminary ruling in Ellis Richards number 1?
Not at all. I think the court is free because the court was focusing only on the question whether it was governmental action that was excluded from Chapter 3. So I think this is entirely open to the court because the court is construing 184.1G, giving it meaning, what is the breadth of the provision, and of course, having determined what it means, does it extend to the claimants? And on the question of consumer and the way that we've treated with it in the submissions in relation to the juridical entities, we asked the court to note that the Grenada Loan and Building Association has played no part in these proceedings. despite being identified on the 17th of July 2023 as one of the 4 test claimants in this matter, and you will find that at page 5434, pursuant to the order of this court of the 3rd of July 2023. You'll find that at 4600. So the intent of the court is that we would have 2 individual claimants and 2 corporate claimants. In fact, as it turned out, giving evidence, and as it turned out, we only have 1 corporate claimant in the person of the Medical Benefits Board giving evidence before you. But I think our submissions in relation to whether they are consumers or not would apply in any event. And I think the evidence of the witness for the Medical Benefits Board is that it was received in the course of business. So we say both on the facts and the law, the claim can't succeed. Even the claimants were able to persuade the court that Article 184(1)G confers rights, a fortiori in as wide terms as they contend it does, we say, first in respect of the claim founded on 184(1)G and 7, applying Mary number 2, the claimants have failed to establish even a prima facie case of discrimination, in that they have failed to establish the criterion of similarity of comparator. That is, that Baco and BAT were the same, or in all material respects the same, to use their language, 2 arms of a single Trinidad and Tobago business, or that Baco assets were used to fund the CLF bailout. And I heard my learned friend make that statement repeatedly. There's no evidence of that before you. None. What Baco asset was used by the government of Trinidad and Tobago to fund the CLF bailout? What? And if the court can think of none, it's because there's no evidence of any. There is no evidence to substantiate the submission that the claimant's funds was funneled through bank accounts in Trinidad and Tobago and ultimately commingled with assets of CLF. The claimant's own evidence through Ms. Green Thompson, Mr. Otway, is that Baco had bank accounts in Antigua and Grenada, and we put bank statements before you of the branches. In any event, we say there was ample, objective, and reasonable justification for the difference in treatment. BAT was the subject of CLF's request for assistance. Baco was not. BAT was registered to carry on insurance business in Trinidad and Tobago, subject to the Trinidadian regulatory regime. Baco was not. And it was in fact subject to the regulatory regimes in all the jurisdictions in which they operated. The failure of BAT had an impact on the economy of Trinidad and Tobago. Baco did not. And my learned friend makes the bold submission, well, regulatory regimes are irrelevant. How could it be irrelevant? If we're talking about redress for consumers, each regulatory regime, like Trinidad and Tobago, had a provision equivalent to the statutory fund. That was the redress. What happened was the statutory fund was in deficit in all the jurisdictions, and that's how the policyholders lost their money. But it is relevant that in each of the jurisdictions, there was redress for consumers, and then when the statutory fund failed, the insurance regulators went to court and asked for the judicial managers to be appointed in each of the jurisdictions. That is the redress. The redress is not to go to one jurisdiction like Trinidad and Tobago or Barbuda or Guyana and say, well, you did that for your nationals, and it must follow logically that you must do it for all policyholders of Baco. It doesn't follow with respect.
Mrs. Speaker, I take it that when you mentioned about Baco assets, that they were not used, you said there is no evidence. I take it that your answer, because we heard it from Mr. Davenport several times today about the common pot. That is what you are speaking of. Could you drill down a little for us, please? Because we were getting the impression that various assets of Baco were being put in this pot, and the government of Trinidad and Tobago accessed that pot to pay out Trinidad and Tobago nationals. So if you could clear that up, I would really appreciate.
If you could just read from my learned friend's submissions at paragraph 57, you'll find it's at page 9722. This is what they say. The notion of BA international assets in the context of the present case has to be understood throughout as covering not only assets held directly in BA International's name, but also all assets which should have been held in its name and to which it has a claim. And then they go on. The precise value of assets involved will thus require assessment and tracing consequent to the declarations and orders sought by the claimants in the present action. There is no evidence, whether from the claimants or the defendant, saying that any assets of BECO, and my learned friend said, well, it doesn't have to be a physical asset, it could be any asset, was brought into any pot for the purpose of repaying government. There was none. As a matter of fact, the evidence before you, and I think it's in the financial statements of BA International, is that there was a loan outstanding to BAT of about $147 million. And in fact, the evidence is the largest contributor to the Green Island, aborted real estate transaction was BAT. So there was no asset. What asset did BECO have? BECO in Bahamas had none. In each of the jurisdictions, there was some property. And I see my learned friend, Dr. Anthony here. In St. Lucia, the statutory fund was good enough to pay off the policyholders. So what were the assets? Was there property in Grenada that was brought into the pot to repay government? No, there's no evidence of that. It was all one way. The government bailout to BAT is still largely unrepaid. So when my learned friend comes to address you again, maybe he will, perhaps he could direct you to where any evidence is to be found, any BECO assets which was used by the government of Trinidad and Tobago. And if we go to paragraph 78 of the witness statement of Ms. Leachy, remember they were giving it, CLF was giving information to government and central bank in dribs and drabs. The obligation on CLF was to say, what assets do you have and are they encumbered or unencumbered? And at 78, this is what Ms. Leachy says. The list of 18 February 2009 was stated to be based on the latest information provided by our group finance department. In respect of BECO, it stated, CLF owns 82% of British American, with the remaining shares held by minority holders. The company does not have any positive equity and is assumed to have no value. And this was very different from what Mr. Carballo had represented in an earlier email. So, no, no question of any quid pro quo. We never got any BECO assets. Just continuing on the point of the objective and reasonable justification, refer the court to the Ryanair cases, which you will find at our tab 7 and 8 at pages 11087 and 11106, which make it clear that state aid measures are inherently selective, and there's a high threshold to cross to establish a claim in discrimination. With respect to the claimant's third claim, as they call it, that founded on an alleged breach of 184(1)G alone, we say without prejudice to our submission that this provision is incapable of giving rise to rights on the part of the claimants, that there has been no breach of this provision, and the evidence is that measures to provide some degree of redress were put in place by the Bahamas, the BECO state of incorporation, and a member state of CARICOM, judicial management, which led to proceedings being instituted in the United States and in Trinidad and Tobago to recover sums due to BECO. The states of Antigua and Grenada took steps also by way of judicial management and gratuitous steps such as the annuity relief program. And the state of Trinidad and Tobago, in fact, made gratuitous donations to the Eastern Caribbean Currency Union, totaling US $86 million. These are all matters that the claimants conveniently ignore, but which we submit the court must take into account in its assessment of this case. Now, my learned friend, in his submissions a little while ago, talked about the US 100 million promise. You will find that referred to at paragraph 54 of the re-amended originating application, which you will find at page 4619. Now, on that
Paragraph
issue,
is it? I'm sorry.
54.
54. Thank you.
paragraph 54 at
Thank
page
you.
4619. And we'd ask you to note that that paragraph comes before the claimant's contentions on the applicability of the treaty. So in other words, that was a recital, as it were. We did not understand that, and we made that point in our submissions, that they seek in their submissions to now make that a ground of complaint. Well, first of all, it has to come under 184(1)(j) and Article 7 for that to be justiciable at this stage of the proceedings. What we say, and the PS did say quite frankly, yes, it was a commitment. One can't escape that. The minutes of the CARICOM heads of government, are before you. But what is also before you is that in addition to that statement that the government, would provide additional financial support of US 100 million to the governments of the Eastern Caribbean Currency Union, the unchallenged evidence is out of that. Government provided 36 million US dollars. And in May 2013, the Minister of Finance formally applied to the Caribbean Development Bank. That was a term of the promise for a loan, but those negotiations failed. And you will find that at paragraph 152 of Ms. Leachy's witness statement at page 5509. And by letter of the 5th of July 2016, the Minister of Finance of Trinidad and Tobago wrote to the governor of the ECCB and indicated that due to unfavorable economic environment precipitated firstly by the financial crisis and secondly by the prolonged low commodity prices, government was unable to provide further funding to the ECCU in respect of the resolution of the vehicle collapse in the ECCU countries. And you will find that at paragraph 155, page 5510 of the witness statement.
Mr. Speaker, I had asked Mr. Davenport about this fourth ground and what rule or article under the RTC, because this is a court in its original jurisdiction, whatever other justiciable rights may arise somewhere else. But he never, at least to my recollection, was clear in where that may be grounded, except, I think, a reference to Article 9. So I just bring that to your attention in the event you want to respond to that aspect of it. We have noted what you have written in your submissions about the point, obviously,
Yes,
insofar as it's being debated here.
yes.
Yes, I'm sorry that counsel wasn't able to develop the point. Perhaps he ran out of time. I'm not sure. But like my brother, Justice Jamadar, I was intrigued by how he would have situated that obligation, because as we are aware, unilateral statements made at the international level can be binding, and there are cases where this has been the case, but there are so many difficulties. The pleadings, for example, I agree that it wasn't stated, and then the way the case has been narrowed by virtue of our first decision, it becomes difficult to bring that here. So I'm not encouraging this at all, but maybe this is a different case. But I was intrigued by that $100 million promise, but I'm not sure how far we can take it in these proceedings.
Well, Your Honors, I would hope that the court doesn't take it anywhere, because apart from the pleading point, it can't be grounded on anything, certainly on the 184(1)(g) and 7, which is the limit of the case so far as the court's ruling is concerned. But as you pointed out, Justice Anderson, look at Article 222. How can he locate it? The court will have to determine that this treaty intended that this right or benefit conferred by or under the treaty, which he hasn't been able to locate any provision in respect. I don't think Article 9 assists him, shall inure to the benefit of such persons directly, and the persons concerned have established that they have been prejudiced in respect of the enjoyment of the right. I really don't think it can get off the ground, and I would hope that the court would not, the court would not make any statement in regard to the undertaking given by government, because one doesn't want to discourage governments
Right.
from making statements where they proffer assistance to less advantageous member states of CARICOM. And I take an example. If tomorrow the Prime Minister was to get up and say, look, I think having regard to the horrendous situation in Haiti, I want to, undertake that I will commit the government to give $100 million. And he goes to the Minister of Finance and he says, Minister of Finance, find $100 million for me. And the minister says, but Prime Minister, we have a budget deficit. We simply don't have the wherewithal to, make good on that commitment. And the Prime Minister has to get up and say, I'm very sorry. I thought we had the wherewithal to make good on that promise, but unfortunately, we're not able to do that at this stage. Do we really want to discourage governments from going to a CARICOM meeting and saying to the members when faced with, terrible situation, look, I will do my best to assist you to this extent. But it's at this condition, we would go to the Caribbean Development Bank and raise $40 million. And if you're not able to raise $40 million from the Caribbean Development Bank, how can you be bound by that undertaking? So, I mean, there are a number of reasons why we say it can't get off the ground. They never got special leave to argue that point. So they never got special leave. It's not part of the pleaded case. It's not part of the case that's been allowed to go forward by this court by the preliminary decision. And therefore, with respect, they can't get off the ground. And, as one can say, you can't get blood out of stone. You can have the best will in the world, but you have to find the money. And of course, states have competing demands for the money. It's not like the United States where we could get up overnight and say $95 billion to Ukraine. Printing money. So that's what we say in relation to the gratuitous promise to advance further monies. It was, of course, subject to Central Caribbean Development Bank giving us the funding, and of course, subject to available of funds. And we see no rights of the claimants under any of the two provisions of the treaty that they are entitled to pursue their claim on have been breached. On the issue of damages, we say no question of damages arises as the claimants fail in their claim both on the law and on the facts. For completeness, we note that while the claimants in their reply submissions to CARICOM rely heavily on the European Court of Justice jurisprudence, this court has in Hummingbird, Rice Mills, and Suriname, you'll find that at our tab 15, page 11353, pronounced as a matter of community law that the threshold for an award of damages is high, and the claimants must prove that they suffered substantial loss as a result of the alleged breaches of the RTC by the state. In our respectful submission, the claimants have failed to do so, and as their own evidence establishes, as confirmed under cross-examination yesterday, their losses are attributable to misleading and negligent misrepresentations made to them by BECO agents, bad management decisions, and failed investments on the part of BECO, a private company, which was at all material times under the regulation of regulators in their respective jurisdictions. Before closing, we wish to address some of the points made in the claimant's reply submissions filed on the 19th of February 2024, and those filed in reply to CARICOM on the 11th of March 2024, to the extent that we have not already dealt with them. First, to the extent that the claimants contend that the European cases cited in our written submissions have them, we are well aware in citing those cases that the framework under which they arose is quite different to the framework we are dealing with under the RTC. Unlike the RTC, the EU treaties contain specific provisions with respect to the grant of state aid. And if we could just bring up Articles 107 and 108 of the Treaty on the Functioning of the European Union, you will see that they make specific provision in their treaty for state aid. it's very small on the screen. I wonder if we could enlarge it and have it occupy the entire screen. I think the court would need to see it. You have it?
It's not on the screen at all.
Yeah, it's right.
This is on the
I think
right.
It's here. It's a little,
Right.
It's not legible. It's not readable.
No.
It needs to be pinned, I think.
it needs to be pinned. Yes.
Some technical assistance is coming up.
There you
Yes, so this comes under section 2 of the treaty, caption aids granted by states. And 107 says, save as otherwise provided in the treaties, any aid granted by a member state or through state resources in any form whatsoever, which distorts or threatens to distort competition by favoring certain undertakings or the production of certain goods, shall, insofar as it affects trade between member states, be incompatible with the internal market. And it goes on into the following shall be compatible with the internal market. I'm not going to read all A, B, and C, but you will see in B, aid to make good the damage caused by natural disasters or exceptional occurrences. So certainly in our respectful submission, what occurred at the beginning of 2009 would qualify as an exceptional occurrence. And then 3 goes on, the following may be considered to be compatible with the internal market. And then there follows A, B, C, D, E. And then Article 108 says, the Commission shall, in cooperation with member states, keep under constant review all systems of aid existing in those states. It shall propose to the latter any appropriate measures required by the progressive development or by the functioning of the internal market. And 2 says, if after giving notice on the parties concerned to submit their comments, the Commission finds that aid granted by a state or through state resources is not compatible with the internal market, having regard to 107, or that such aid is being misused, it shall decide that the state concerned shall abolish or alter such aid within a period of time to be determined by the Commission. So that is their regime. We don't have any equivalent provisions. Under the EU treaties, the EU Parliament and the European Commission, both supranational institutions operating in the context of a political, economic, and monetary union, have a role in regulating and approving state aid. As this court has said, the RTC creates a customs union, and we submit that there are no supranational institutions in play which have the powers that the EU institutions have. So our objective in citing those cases was to demonstrate that even where the grant of state aid has come before the court in accordance with the treaty on the functioning of the EU, the concern of the European courts has been whether state aid interferes with the operation of the internal market, and there's no evidence of that in this case. Unlike the EU, which is a political and economic union, member states have not ceded sovereignty to CARICOM to make economic policy or to take measures to safeguard their economies. And we made this point in our submissions at paragraphs 26 to 29, pages 10888 to 10889. It
But
relies
in any
on
case, that is primarily a different kind of case, isn't it? That's a case on distortion of the internal market
yes,
and
correct.
competition.
Yes.
Not
But
this kind of case.
the starting point is state aid,
Yes.
which is what this
yes,
is.
Yes.
So it's not every state aid that is regarded as impermissible. It must have a deleterious effect on the internal market.
Absolutely.
And we relied on the express terms of Articles 14, 43, 44, 68, and 70 of the RTC. The claimants have not addressed these provisions of the RTC and their effect on the submissions which they seek to advance. And we say it is right law that the RTC has to be interpreted as a whole. We submit that there can be no higher attribute of state sovereignty than for a state to decide the causes on which it wishes to spend public finances gratuitously or to give financial assistance not having anything to do with the free market or trade in goods and services, which is the subject matter of the treaty. This happens routinely in the global context when more developed countries give aid to developing countries, and there's no suggestion there that a sovereign country cannot choose to whom or to which country it wishes to give financial aid. Unlike the EU, CARICOM is not a currency union, nor is it a supranational legal order where member states have ceded legislative competence. There's no CARICOM parliament which approves a CARICOM budget and which appropriates funds across member states. Now, to the extent that the claimant suggests that, and to quote their reply submissions at paragraph 38, page 11286, that the defendant should have treated all CLF subsidiaries in the same way, we respectfully submit that the breadth of this submission proves its unworkability, and in our respectful submission, its absurdity. The court has before it CLF's annual report for the year 2007. It's annexed to the re-amended originating application at Annexure B, and you will find at page 4923 CLF's principal subsidiaries listed. There are 42 subsidiaries of CLF, and that doesn't include their own subsidiaries. On the agreed terms of the MOU, CLF requested assistance in respect of 3 identified affiliates, CIB, CLICO, and BAT. Board resolutions were provided and evidence before the court demonstrating that CLF was authorized to enter into the MOU on behalf of these affiliates. And you will find that at pages 5998 to 6004. And we ask rhetorically, if the claimant's submission on this issue is correct, which we say per the Ryanair cases they are not, where were the taxpayers of Trinidad and Tobago to find the funds to treat all of CLF's 42 subsidiaries in the same way? Our submission is that this is not grounded in reality. For completeness, and to the extent that the claimants contend at paragraph 31 of their reply submissions at 11284, that the state caused assets of BACO to be used in funding the bailout, as we submitted at paragraphs 35 to 39 and 42 of our submissions, pages 10891 and 10892, there's no evidence of this whatsoever on the facts of this case. So for these reasons and those set out in our written submissions, we submit that the claimants have failed to make out their claim in law and in fact, and we respectfully invite the court to dismiss the claim with cost certified fit for senior and junior counsel. And in making these submissions, Your Honors, it's not that we don't empathize with those who have suffered. My learned friend's submissions began with a very dramatic reference, not in relation to the evidence before you, I hasten to add, of persons who might have been adversely affected. That is the reality, and we don't run from it. But one cannot translate that into jurisprudence based on community law and based on the construction of the treaty. My learned friend's case stands or falls on whether they've been able to make out a case under 184.1J and Article 7 insofar as it's applicable. And in our respectful submission, they have signally failed to do so. Unless there's anything else we can assist you with, those are respectful submissions.
Yes, thank you very much, Mr. Speaker. Madam General Counsel, you have been a patient, silent listener to the proceedings the last day and a half. Would you like to address us at this point?
Certainly, Mr. President. Happy to do so. I start, of course, by recognizing that with me are Ms. Radha Permanand and Mr. O'Neill Francis, acting on behalf of the community. I want to take the unusual step, Mr. President. Can you hear me clearly?
Yes, we're hearing you very clearly.
Thank you. I want to take the unusual step of thanking the court for inviting us to give our views as amicus curiae on the matters of treaty and treaty interpretation. We recognize, of course, that in our community, this is the job, ultimately, of the CCJ, but that we also have a responsibility as community to also assist the court in whatever way that we can in terms of interpreting the treaty. We have, I think, benefited very much Mr. President, thank you and your honors for including us and for having us benefit from listening to the proceedings here. I don't know, your honors, that there's anything that the community could usefully add that has not already been said, and certainly we would not be here commenting on the facts of the case themselves, but on the way that the treaty is interpreted. I think both the claimants and the defendants have cited the intervention that we have made, and both have tried to spin it, if I can use that term, in such a way that best suits them. We tried to be as clear as we could. If your honors would permit, I would just want to say a word on Article 9, because I think that whether your honors agree to have this included as a ground, your honors might be assisted by knowing that as far as the CARICOM is concerned, Article 9 is a general undertaking on implementation, and it requires member states to take all appropriate measures, whether those are general or particular, to ensure the carrying out of obligations under the treaty or those resulting from decisions taken by the organs and bodies of the treaty. And obviously, the first and most principal organ of the community is the conference. Yesterday, we heard Mr. Davenport cite a decision, as he called it, from the Conference of Heads of Government of the community, and I believe the citation he gave was as to the 33rd regular meeting of the Conference of Heads. By serendipity, the chair of that meeting was Dr. the Honorable Kenny Anthony, Prime Minister of St. Lucia, at the time as he then was. And what occurs, Mr. Chairman, from the report of the Mr. President, of the 33rd regular meeting held on the 4th to 6th July 2012 is that in terms of BACO/CLICO and CLICO International Life Insurance, there was a discussion as to the resources to be provided by Trinidad and Tobago towards resolution of BACO obligations to the Eastern Caribbean Currency Union, as agreed with the Prime Minister of that member state during the 23rd intersessional meeting held in Suriname. And there is reference to discussions held in caucus, and the Foreign Minister of Trinidad and Tobago advised of the following agreements. A, Trinidad and Tobago had reconfirmed its commitment to provide US $100 million to resolution of the BACO obligations, and how that commitment will be worked out was referenced, an immediate transfer of US $36 million, which I think is confirmed that was done, a US $40 million loan by Trinidad and Tobago from the Caribbean Development Bank, which my learned friend Ms. Peak, I think, has already addressed, and that the governments of the Organization of the Eastern Caribbean States would provide additional resources to resolve. The decision taken by the conference, Mr. President, is only to note the final report from the Regional Technical Committee established by the COFAC, and to note the update provided by the Eastern Caribbean Currency Union, and therefore to subsequently note and recognize the need for greater cross-border regulation and supervision of the regional financial section, and with respect to the contribution of Trinidad and Tobago to the resolution of the BACO obligation in the ECCU, it was simply to welcome Trinidad's reaffirmation of its commitment of financial support in the sum of 100 US million for BACO policyholders. This was not, Mr. President, a obligation or decision made by the conference to provide these funds. All the conference did in that meeting was to welcome the commitment that was given by Trinidad and Tobago. That commitment was also examined in terms of the 24th intersessional meeting of the Conference of Heads of Government of the Caribbean Community in Haiti on the 18th to 19th February 2013. And I think this is previous to what Ms. Peake referred to, that negotiations fell apart. I simply refer to it to point out that there was no confirmation or no decision made by conference to underpin any community decision being made as to these funds. And in fact, there was noting of requests from the ECCU government that the disbursement of funds be expedited, but also a request from the government of Trinidad and Tobago for clarification regarding progress on the conditions precedent to the transfer of funds from the resolution of BACO obligations. Therefore, I cite all of that to say that from where CARICOM is providing assistance to the court as amicus, we do not see that there was any decision of the community to engage Article 9, whether as a standalone or whether as an adjunct to any other treaty obligation in this case. Like the defendants, we are very clear on the issue of Article 184J as being one of a number of things that the community expresses shall be promoting or promoted as the interests of consumers of the community by appropriate measures that do several things, and that this is in terms of promotion and has to mean that you promote these things by actioning Article 185, and that 184J cannot simply be separated and made to stand alone without member states taking those steps to protect consumers in the community by making Article 185 come into effect, by having Article 186 actioned, and so be able to provide the architecture or the framework by which such consumer protection would take place.
Question on that, please.
Of course, Judge.
Would you say, I think Mrs. Peake said it explicitly or may have hinted at it, sorry. Yeah, would you say that member states, let me just get the article so I don't misquote it. Yeah. That in this context, member states promoted the interests of consumers by providing adequate and effective redress by, among other things, enacting legislation, insurance acts, which provided, for example, for the creation of statutory funds, and by putting in place different regulations and regimes to protect the interests of consumers insofar as the provision of insurance products and those services, goods and services are concerned? Is that the way CARICOM construes it? I don't, so that I'm just trying to understand then, from your perspective, the obligations on CARICOM states to put in place certain things to protect interests. We're talking about the provision of insurance products, goods and services. And Mrs. Peake suggested that I think that this has been done regionally in the ways I've just described. Is that the way CARICOM sees it also, or do you see it differently, or how do you see it?
Yes, Your Honor. I cannot say that I have instructions from the community as to how to interpret this precisely, but I would say that would tend to be the view of the Office of General Counsel, that yes, this is one of the ways, and that the rest of how that could be done would also have to be by developing what is there in Article 185 and 186, which is why we say there is still yet specificity that has to be added in order for there to be a requirement for anything more. That at this stage, at least, at this stage, it would be enough. It would be going along the road of promotion.
You mean what has been done so far is going along the road of protecting the interests of consumers in the realm of insurance products and business? But
in terms of Article 184J, yes, Your Honor.
what would, and this may be purely theoretical, maybe even speculative, I don't know, but what would happen if, for example, in the region, states had done certain things like enabling legislation with a requirement of a protection of a statutory fund, equivalent statutory fund, etc., but a single state hadn't done that? It is a little hypothetical, but I'm just trying to ask this question. Well, I'm trying to ask this question. If in the region a state had not taken some of the measures that other states had taken, could that be a basis for a claim of default by that member state?
I could only see that arising, Your Honor, if a national of that state were to bring a claim in a context in which CARICOM member states had, for instance, in a decision of conference, that every member state was supposed to put in place such a fund, or that there was to be one fund to protect, for instance, the consumers of a particular good or service.
All right.
Or if the decision had been taken by decision of the conference that this would fall under some kind of a state aid, and that it had to affect an internal market. Because as Ms. Peake says, we
ahead of a conference decision, discovering whether or not states had provided adequate and effective redress or protection is too speculative to be enforceable? Is that what you're saying?
No, I'm not saying that at all, Your Honor. I'm saying it would depend on the context. It would depend on the right that that individual was purporting to have a right to enjoy under the treaty. If I may, by analogy, there is already certain sections as to rights that CARICOM nationals should enjoy, but the specificity as to how they enjoy it, under what terms and conditions, and so on, fall to either having to interpret the treaty, fall to whether there is an amendment of the treaty, or a conference decision which then becomes law and which then would engage Article 9.
Thank you.
I don't know whether your honors had any further questions for CARICOM or any other matter in which we could assist. I think your honors have heard quite a bit from both parties, and we've had our written submissions in. Both parties have responded to it. We are here to assist in any other way. But other than that, those would be the submissions for the community.
Yeah, thank you very much, Ms. Sherman, General Counsel.
Thank you. Thank you, Mr. President.
I'm sorry. We take the luncheon adjournment here, and we will come back at 2 p.m.
All right.
Yes, Mr. Davenport?
I think you're on Ms. Peake wanted to just say something to start with.
That we wanted to respond to, say that we wanted to report our appreciation for the contribution made by Caracol, placing in context the $100 million that the government spoke to, and by pointing out by reference to various meetings and so on, why Article 9 cannot be engaged because there was no decision taken by the organ or body of the community. Support if it wishes to deal with us.
Yes,
Much obliged.
yes, thank you.
Mr. President, Your Honours, we, with your leave, will do it in two ways. I shall do some submissions on three parts of the reply, and then Mr. Carsten Zatchler will address you on some aspects of the community law, if that's convenient to you. So just to announce that hopefully after our reply, you will see that we are still maintaining our position on all fronts. We believe we have answers to all of the matters that have been raised. We take the seriousness of the matters that have been raised, and hopefully we will give you the material in order to be able to find for these claimants. And I don't shrink from saying that it is very much to be hoped that you can find for these claimants. Sometimes the court can recognise that fact quite openly, and I think in this particular instance it's one that should be. Could I start by dealing with the corporate veil point, hopefully briefly, but anyway, just give an answer to this that Mr. Justice Burgess has given rise to. First of all, the context is all important. It's not a corporate veil point in the High Court sense, in that there is an application to get at a director that is masquerading or hiding behind a corporate veil, and we're trying to pierce the corporate veil in order to be able to get to either a director or another corporate that is actually behind what might be misfeasance. It's not in that sense at all. What we are doing, and we're entitled to do, and it's the right way to go about it, it is trying to establish what's called the economic reality, i.e. the matrices of facts that apply. And that all goes to the question which we have addressed quite fully in our written submissions, and I referred to it again in my submissions this morning, of establishing and answering the comparability question. So it is a factual exercise, not embarrassingly so, without a hook. It is actually the exercise. And the court has recognized, as I'll show you in a minute or tell you, a number of times that is an appropriate way to go about it. But the context is not piercing the corporate veil for the sake of it. It goes to the question of comparability, which is at the center of the discrimination analysis. Therefore, in any way, it would be really, if anything, less formal, easier to overcome than a normal corporate piercing of the veil instance in a court where there are certain expectations. So, but thank you very much for raising it. On the formal or legal side, as a starting point, the principle of piercing the corporate veil is a recognized principle across not just the Caribbean community, but most jurisdictions. However, even if the court doesn't currently recognize piercing the corporate veil, or it's new to this court as a principle of community law, I doubt it is. And in fact, one of the cases I think is one of your cases. We say the following two things to assist you to be able to deal with it. First, the court is empowered to incorporate the principle on the basis that it is a recognized principle common to the principal legal systems of the community, akin to the Caribbean Court of Justice incorporation of the separate legal principle, which was in TCL and the Caribbean community. Also in Trinidad Cement, where the placed reliance on the concept of ultra-vires acts of organs of international organizations, where it considered to be emerging customary international law as forming part of community law. In the case of, I don't think it's before you, although we can certainly supply the case and reference, the Dow Chemical Company and the European Commission, the European Court of Justice held that the decisive factor is whether the parent company, by reason of the intensity of its influence, can direct the conduct of its subsidiary to such an extent that the two must be regarded as forming part of the same economic unit, which would say would be easily satisfied on the facts of this case. And secondly, as an alternative hook, the court can rely on the case or on the principles enunciated in the case of Schindler Holding against European Commission. That's also not in your bundle because I'm afraid we didn't see this point arising, for the principle of examining the economic reality of the companies on the basis that competition law in that case is not guided by technicalities but by the actual conduct of undertakings on the market. And if I may just read out to realize my learned friend can't follow this, neither can your honours.
Do you have the reference for the
Yes, I do have the reference. The Schindler case. No, I don't. I've got a hyperlink, I'm afraid, rather than a reference. I apologise. We can try and get the hyperlink to you. Oh yes, we do have the reference. I've been handed it now. It's case C, capital C, dash 501 / LLP. Yep. And I'll show you 66 onwards, just to give you the shortest part, but obviously you can see all of it at any point onwards. So what the court said in are we live? We're trying to put it on now. Here we go. Right, you can see fairly still. Thank you. In assessing an undertaking's responsibility under antitrust law, in that case, however, the crucial factor cannot be whether there is a corporate veil between the parent company and the subsidiary. What is important is economic reality, since competition law is guided not by technicalities, but by the actual conduct of undertakings on the market. In assessing for the purposes of antitrust law, the effect on competition of an undertaking's conduct on the market, it is irrelevant what legal constructs the natural or legal persons behind the undertaking have chosen to regulate their legal relationships. And then 67, we can see it, the question whether a parent company and its subsidiaries appear on the market as a single undertaking cannot therefore be assessed on the basis of a purely formal legal analysis. It likewise cannot be assessed solely on the basis of company law, whether a subsidiary can determine its conduct on the market autonomously or is exposed to the decisive influence of its parent company. Otherwise, it would be easy for the parent companies concerned to evade responsibility for infringements of the antitrust rules committed by their wholly owned subsidiaries by relying on events falling entirely under company law. And over the page, 68 of my page, against this background, the General Court was right to reject Schindler's objection, which was based solely on grounds of company law, to the 100% presumption and more generally to the union law principles relating to the joint liability of parent companies for the cartel offences of their subsidiaries. Just pausing there, when you consider the facts of this case, I did show one of the minutes of one of the board meetings, which reflects the reality of what was going on. I won't say the word cynical, but a sort of knowing awareness that by a certain way of tactical moving around of assets and responsibilities, that the regulator was dealing with, as it were, an empty Bahamian company, and there was enough to be just keeping the regulator occupied in departments, so that was okay. But the reality was that all other material was being shifted around. And I think that's the sort of thing that the ECJ was referring to when it was talking about looking at the reality. And that's, of course, a matter of now fact for your honours to decide whether or not you'll see it as one side of the line or the other. Can I just also show you, because it will help you, the Dow Chemical Company and the European Commission. Thank you very much. And the reference on this one is case T for Thomas dash 77/08. And we will show you at paragraph 77. Advocate General Cockott observed, are we there? Yep. 77. Or is it the right at the bottom? Thank you very much. Advocate General Cockott observed in points 89 to 93 of her opinion in the judgment of the Court of Justice in Asco Noble, to which the Court of Justice refers, that even if the examination of the autonomy of the subsidiary is carried out in the light of its commercial policy in the narrower sense, the decisive influence of the parent company does not necessarily have to result from specific instructions, guidelines, or rights of co-determination in terms of pricing, production, and sales activities, or similar aspects essential to market conduct. Such instructions are merely a particularly clear indication of the existence of the parent company's decisive influence over its subsidiary's commercial policy. However, autonomy of the subsidiary cannot necessarily be inferred from their absence. A parent company may exercise decisive influence over its subsidiaries even when it does not make use of any actual rights of co-determination and refrains from giving any specific instructions or guidelines on individual elements of commercial policy. And then, helpfully, I think, thus, a single commercial policy within a group may also be inferred directly from the totality of the economic and legal links between the parent company and its subsidiaries. For example, the parent company's influence over its subsidiaries as regards corporate strategy, operational policy, business plans, investment capacity, provision of finance, human resources, and legal matters may have indirect effects on the market conduct of the subsidiaries and of the whole group. In the end, the decisive factor is whether the parent company, by reason of the intensity of its influence, can direct the conduct of its subsidiary to such an extent that the two must be regarded as one economic unit. Thank you. I just mention in passing that it's enshrined in the treaty anyway under Article 217 that the CCJ is required to apply such rules of international law as may be applicable, and that arose, I think, in the Rockhard distribution case, where the CCJ articulated that, and I'm quoting, it was pellucidly clear that the RTC cannot be interpreted in clinical isolation from public international law in general. The provisions of international law within which states are bound must provide some context and background. I leave my submissions there. So that's what I wanted to say in reply on corporate veil. Can I now deal with the challenge I've been presented with, apparently, on assets, which is not a hard challenge to discharge. So to make this clear, we say that from the question being what assets of BICA were used to bail out CLF, to answer that, from the onset, the CLF group operated like one single unit or entity, for reasons I've been on at some length before, and I won't repeat, before the collapse had begun to happen, which we submit can't be a fact in dispute. The Prime Minister in his statement stated that the insurance companies were used to effect the will of CLF, and I've given you the references to that. The funds of BICO were funneled into, at all times, the operations, or were, as it were, used as part of the will of CLF. So BICO, in terms of hard assets, BICO purchased Green Islands on behalf of, well, not on behalf, and transferred it to CLF. And that was a $1.8 billion asset. Now, the money, as we know, it didn't really, or certainly didn't all start or originate from BICO, because it just didn't have enough money for those minutes that we've been looking at. It was the recipient of money by CLECO underwriting part of it, or all of it. But in any event, a CLF strategy to fund BICO. But that doesn't matter, because BICO then was the owner. And if we were operating on strict rules of entities and ownership, then that's BICO's asset. But what we do know, and this was accepted readily by Ms. Lee Chi, it was transferred to CLF. And I showed her the document, which I show you now, which is on the screen. Which was that note 42 to the consolidated accounts. And remember, this is PwC. And just a point in passing, PwC, not only PwC, but I think the same audit team, indiscriminately between all of these companies, regardless of which chain they're in. And so they said, they've noted the simple fact, which I showed her and you at the time, that the group acquired 100% of the share capital of Green Island Venture for cash of $1.86 million. Well, that $1.86 million didn't go into the coffers of BICO. It was circular. And so that is a glaring instance of an asset that was in BICO's hands, a very, very valuable one on the face of it, or a costly one, perhaps is a better way of putting it, and one that then disappeared on the evidence that we have, and which has been confirmed, into the ownership of CLF. Additionally, BICO undertook significant levels of debt to purchase assets such as Green Island Venture and another set of projects, not just one set of projects, the Infinity 2 projects. So the relationship of assets incorporates the consideration of debt. You can't have, you have to look at the both together, hence a P&L sheet or the balance sheet. It's looking at the assets versus the debts. It's an interrelationship. And by increasing debt, that is an interference with assets and an interference with the value of a company, obviously. And the Infinity projects, I think we've got on screen now, 9379 of the KPMG report. And if you look down to when it says Chorus Bank NA, so you can see 3 entries here. These are all loans. So the first commentary is this loan was granted for the purpose of providing funds for the acquisition of Infinity 2, land and other development costs. And then there's some specifics about the loan. And the First Citizens Bank Limited, this loan was granted, this is to BICO, these are all to BICO, to assist with the down payment for the acquisition of Green Island Ventures.
Mr. Davenport, these are all pre-collapse events, right? These are all events happening pre-collapse, before CLF approaches GORTT to make any kind of request. And so your case on this is on the evidence, which you are giving us some examples. Pre-collapse, there's this pooling of funds and movement of funds, which CLF uses as parent company, BICO, to purchase, whether it's real estate or service debts and so on, yeah?
Yes, sure.
And certainly for me, I get the point.
Yep.
So that I think the challenge that was put to you was slightly different. I think what was said was that there is, I don't think it was put to you that there is no evidence about what you are citing. This is my understanding, maybe I'm wrong. What I thought was put to you was this. There is no evidence that post-collapse, GORTT used assets of BICO to bail out.
That's it. Okay.
So that's my understanding
Well,
of the challenge.
Yeah, no,
So for myself, this part, I don't need for you to detail it for me. I
Fine.
get it.
Yep. I pretty much finished anyway.
Yeah, okay.
But I was going to go on and as a,
Sure.
not on the pre-collapse assets,
Yeah.
but to deal with, I think, what would be the answer to Your Honour's question. And that is that, as we know, there was no distinction between BAT and BICO. And the funds of BICO were used by BAT throughout that pre-collapse, and based on the evidence of Glenn Otway, you had direct evidence from him, including the fact that there were no access to bank accounts. But afterwards, there are at least two, maybe three examples that you have got of asset transference. And the first is the entirety of BAT. So BAT is an asset which is owned by BICO 100%. And it isn't made a party, unless I'm right in my interpretation on the words I said to you this morning when I said, when you look at it, look at the words included, look at the words affiliates, and look at the word not restricted to, without limitation, I think the words are. So argument number one is they are party, but the end point anyway is that the entirety of BAT is used for the purposes of the MOU, and I think the shareholders agreement as well, and in a complete sense. So there's no getting away from it. BAT is a company which is completely owned, lock, stock and barrel, by BICO. And it's actually misrepresented in the shareholders agreement. You may recall that I showed you briefly this morning that they were shareholders agreement tried to show that
So the point is,
Yeah.
BAT is an asset of BICO.
Yeah, it is. No, I did just want to say this one point because I find it interesting, which is that in the shareholders agreement, incorrectly, unless it means that BICO is party to that agreement for another reason, but they refer to an 82% to the ownership of BAT, but BAT was owned by BICO, not by either CLECO or CLF or CIB. And then you've heard, and I don't think there's been any satisfactory answer to this, you've seen evidence, we dealt with it actually in live evidence, of the suppression of the loan action. And that was somewhere between $39 and $50 million with interest. And that was inuring to the right of for BICO, and that was suppressed. And then the third asset, which I cross-examined upon, was one of these minutes which made explicit reference to the requirement of CBTT to replace a land asset with another. And the company's asset that was used was a BAT land asset. And for those reasons, therefore, that counts as a BICO asset. So, and that leaves aside any of the points, the general points, which have been referred to by my learned friend in our submissions about what might come out in the wash in any sort of tracing or following aspect of this, which would follow on from the grant of the principal relief that we were seeking, namely to put the parties in the same position, as it were, the working out of what the same position would look like. So I hope that that helps. The only other point I wanted to deal with, thank you. The only other point I wanted to deal with were the facts, not the CCJ or the RTC points on the $100 million, but I do want to hold my learned friend's feet to the fire on one or two of the factual points which go with the $100 million treaty. And obviously I heard Mr. Justice Anderson and the observation that it may not be, maybe resignedly, the $100 million isn't going to make it, as it were, for serious consideration in this case. I honestly hope that that is not the case, that the material is here and that really requires the court to look at it. I accept that it might not arrive in concourse condition to the court. But if there's justice when weighing it up, I hope that we can remedy those dents and dings because what lies behind it is important. And it's important on two aspects. The second aspect I'm not going to deal with today, but is the evidentiary aspect, which goes to the question of why was it being offered in the first place, as a context. But I addressed you on that. But just in respect of some of the other facts and observations of my learned friend, which I really would like to pick up on because it's just not satisfactory in my respectful submission, is first of all, as to the pleading, since we're being in strictu sensu lawyers, the pleading was dealt with. I'll just give you the references. Paragraph 54 was the principal part of the pleading in the claimant's claim, originating application. But I draw your attention also to paragraph 8 of the relief. And paragraph 8 of the relief is a wide cast of what the relief can contain, tying it into a just cause. Now, if that had not been, as it were, an issue between the parties, in any way, then you would expect the defendant to ignore it or not feel constrained to deal with it. But the defendant dealt with it at great length. The defendant pleaded paragraphs 83 to 93 inclusive on, as it were, the government's contribution, and very specifically, 3 quite long paragraphs, 87 to 89 inclusive, on what they did. And as I said, the evidence of the witness, Suzette Lee Chi, and the defense look sort of word for word the same on this. And we will remember the figures are 36 million paid, which was paid, followed by, 40 million and 24 million at the end. And can I just show now the court, the document at the end of that, which was the, thank you. So if you can just look at it there, with respect to the contribution of Trinidad and Tobago to the resolution of the obligation, having discussed this matter initially in caucus, she agreed with me that it was caucus first, plenary second, and then communique third. And the conference then welcomed Trinidad and Tobago's reaffirmation of its commitment of financial support in the sum of $100 million for BICO policyholders in the ECCU and its preparedness to begin immediate disbursement. And by the way, can I just pause to interrupt? My learned friend scouting around and saying there are 42 subsidiaries, what are we meant to do in these circumstances? It is, in my respect, a little bit tongue-in-cheek, because there's only one other insurance company selling policies to victims, as they've turned out to be, and that's the insurance company, and BICO is the only other one. So we're only looking at one other insurance company. And now, as the witness agreed, and I put this to her, and she didn't duck it, she dealt with it, as Mr. Justice Jamadar reminded me this morning. And she agreed with me explicitly, this is the evidence, that this wasn't a conditional offer. And this obligation was, I think she was ahead of me in terms of the wording, but it was a binding offer. And she said that quite clearly. Now, the fact that we can see for ourselves what the breakdown says, it speaks for itself, but that is not conditionality. And my learned friend actually used the word term of the offer. It wasn't a term of the offer. That the signing up to this was actually unconditional, agreed to be binding, and not only that, but the witness agreed that there would be reliance upon it by those other states and the people behind them. She accepted that that was the case. And then the learned friend says, well, it was a term. Even if she was right that it was a term, which she's not right about, it doesn't actually say that it is exclusively to be coming from the Caribbean Development Bank, and if it doesn't come from them, it doesn't come at all. Where's that written? There's absolutely not written. It's not a free hit, as if we can't get it from this bank, then it doesn't happen. And she's literally, and the defendant has literally avoided, ducked the $24 million question. That's not meant to be coming from some specific source. That's meant to be coming from other sources, including.
Mr. Davenport, wait, I'm a little bit at sea here. Forgive me. I thought counsel for CARICOM shared with us the minutes. I've forgotten what meeting this is now. I'm looking to see what it is now. But whichever was the community meeting where this decision was taken, I thought the conference notes and decisions, I thought council shared with us that this $100 million promise, whatever you want to call it, had three aspects. It $26 million to be paid immediately by the government of Trinidad and Tobago, which
36. Yeah.
36, which was paid. 40 million to be paid, provided they could raise it on a loan. And then the balance, I thought, to be raised by the OECS. I thought that's, I may have misheard, but I thought that's what the Council for CARICOM read for us from the actual documents. Are you suggesting that we disregard that and choose to accept what is on the screen as the full statement of what was agreed to by Trinidad and Tobago?
I'm not. First of all, I didn't understand that that's what she was actually saying. So if that's your understanding, then of course I will defer.
No, you and I both heard what she said. I thought she was reading from, and maybe she can clarify for us.
I have to say, I thought she was talking about the context of the reaffirmations. What she said was she was talking about what happened in 2013.
And this is when?
This is 2012.
I see. Okay.
I think she did. Didn't she deal with both?
Which she might have.
Yes,
I'm not,
I thought she was very clear.
Then I apologise. The case has got to me. I can only say that. But if that is what you understood to be the case, then of course I will defer to that, and I will not stand in the way. However, I have to say I interpreted that what she was saying as a sort of status interpretation of what was going on, and
as opposed to what was
what was
decided or agreed,
as opposed to facts and evidence. I mean, she's not giving evidence, but we're not going to stand on ceremony. I readily accept that. So I'm not going to take that point, but I didn't really think that what she was saying was primary evidence. But I don't want to be viewed as somebody who's being difficult in any way, shape, or form.
No, I think it's a question of clarifying the facts.
Yeah.
So thank you.
Okay. Well, such facts as I wanted to draw to your attention included the fact that the $24 million didn't arrive and it hasn't ever been expressed away. And I have to say, what Ms. Sloman said this morning hasn't been put as a pleaded case or in any way in the evidence or in any way in any other form by the defendant. And it wasn't said by the only witness that they called to the event, who said she had complete access to all the books and records. So forgive me if I'm not particularly up to speed on that, because what we had seen was that there had been affirmations and reaffirmations, and I'd rather thought that she was talking about, as it were, what they amounted to. But if I'm wrong about that, then I don't want to tie, as it were, the rest of what I'm saying to that. And that was just my takeaway from it. But if yours is different, then I give ground. In any event, that brings my part of this to an end. And I'm going to give way so that Mr. Zachler can address you on some aspects of the community law. I'm very grateful.
Yes.
Mr. President, honourable members of the court, I'm very grateful for the opportunity of being able to address you. I intend to deal, as Mr. Davenport said, with a number of the treaty points that arose. I will start with the jurisdictional point that was raised early on. We of course recognise that by virtue of your order, we are limited to Article 184(1)(j) and Article 7 RTC insofar as it applies. I think as regards Article 184, it's uncontroversial that there is not a jurisdictional issue at any rate. And in the light of your Douglas decision, indeed it was understandable that your order should have contained the qualifier at the time insofar as it applies, because of course Douglas can be read, in fact it contains those words, as excluding any self-standing application of Article 7 RTC. I'll come to that in a second. Now, in relation to Article 7, and I don't say anything new compared to what Mr. Davenport said this morning, we say that Article 7 does give rise to an independent right in any event, and it is a right capable of self-standing application. But there's an important distinction, I think, that I should make here at this stage already. What we mean by self-standing is we mean that it's self-standing from other treaty provisions, but not self-standing from the treaty as a whole. So in other words, it still needs to fall within the ambit of activity, that is economic activity regulated to the treaty. But we don't need to cite a specific treaty provision, say it is when you apply this treaty provision that Article 7 becomes relevant. We say that what we need to show is that the case is in the realm intended to be regulated by the RTC, economic activity. And once we're in that realm, Article 7 can be applied. So in the light of that interpretation, I'll take you to Douglas in a moment, if I may. We basically say Article 7 applies across the board. So when the order says RTC, Article 7 RTC, insofar as it applies, we say that is not actually a real limitation, because Article 7 on its own is capable of application across the board. Let's look at Douglas in particular in a second. Mr. Davenport already took you to Phil Collins this morning. We've got Phil Collins, Data Director, and a number of other ECJ authorities that we rely on. All of those show that economic activity per se is sufficient to trigger the non-discrimination provision. And what I intend to show is that it's the same position, should be the same position in the realm of the RTC as it is in the realm of the EC treaties. Now, Douglas, I think the first thing to note about it is it was a free movement of persons case, as was Myrie. And free movement of persons cases are subject to additional also political sensitivities. I think it's right to recognize that. The free movement of persons is not as liberalized, let's say, as other economic freedoms are. Now, do you have it? Can we have it? Ah, yes. Can we have? This is Douglas, and can we have paragraph 10 of Douglas on the screen? This just to give you the context, to remind you. I'm sure you're all reasonably familiar with it. But paragraph 10 of Douglas makes the brief point that the applicant in Douglas has asserted that he's a national of the respondent. So he was actually asserting, or seeking to assert, discrimination against the country that he was a national of. And if we then turn to paragraph 15, over the page, we see that the court, I would respectfully say entirely rightly, gave very short shrift to that argument. Because, of course, it is rather makes a nonsense of the treaty if you assert discrimination on the basis of nationality against your own country. So paragraph 15, I can just about read it, says Article 7 can have no application to the applicant on that basis. I won't read out the remainder of that. And that then takes us to really the crucial paragraph, which is paragraph 16. Paragraph 16, first point Mr. Davenport made it this morning, is in our submission, it's obiter. In paragraph 15, the court has already said there's no application to the applicant. So 16 also starts furthermore. But then there's something interesting that I have to say I hadn't seen until I was looking at it again this morning. Because in paragraph 16, indeed, the court starts saying Article 7 is not a standalone provision, but rather was adopted to ensure that the rights inuring expressly or by necessary implication upon persons of the community were not thwarted because of discrimination on the basis of nationality. Article 7, and this is an important sentence to my mind, Article 7 therefore does not confer an inherent substantive right, but rather provides the the rule by which the framers of the treaty intended to ensure, now it comes, that the rights granted, whether expressly or impliedly, were not distorted. And we say, I would in any event submit, that here, by making that distinction between rights expressly or impliedly granted, the court made the very point I made by way of introduction, namely that you do not need to actually be able to cite a specific treaty provision, an express treaty provision that you tie yourself to. It is sufficient if you have rights implied from the treaty. They don't need to be enunciated, so you need to be within the framework of the treaty. And that very conveniently, of course, gives us a possibility of not needing to distinguish Douglas at all, but merely saying that it actually supports the proposition that in a situation that is factually different from that in Douglas, because remember, in Douglas, it was clear that the treaty as a whole did not apply because the claimant was trying to rely on it against his own state. So there's no application of the treaty. That's a very different situation from the one we have here, where we indubitably have an economic activity that is cross-border and that in the ordinary course obviously falls within the realm of economic activities that fall within the realm of the RTC. So we basically say on that reading of Douglas, we don't even need to distinguish it. It supports, if anything, the proposition that we can rely on Article 7 RTC in isolation. This takes me to another point, my next point, on comparability. And the very, if you don't mind my saying so, I found an interesting question brought up by Mr. Justice Anderson as regards the comparability of the 1,000 plus non-Trinidadian policyholders of CLICO compared to the nationals of Trinidad and Tobago who were policyholders of CLICO. And Your Honour took us through a number of elements where in that situation, obviously there were many more similarities between the nationals and the non-nationals. So there were, for example, the regulatory climate you alluded to would also have been similar, the jurisdiction, place of establishment of the company concerned. Certainly there are fewer distinctions. Now, I don't want to be overly simplistic, but I think that the core point I would like to make in this regard is that it's not sufficient, of course, to identify a range of distinctions. What one needs to think about is whether these distinctions are relevant ones to the claim that is actually being advanced. I hope you forgive me for being really very simplistic, just to bring home the point. If there were some policyholders who bought their policies on Mondays and others who bought it on Wednesdays, that is a distinction, but it is not a relevant distinction in any of the contexts one can think about. So what one needs to think about is the distinction a relevant one for comparability purposes? And from that point of view, and that's why Mr. Davenport spent some time this morning on the question of what is the nature of the claim, what is not the nature of the claim, what is the nature of the claim. Context of this claim is not a regulatory claim. We do not rely on any breaches of the regulatory framework, regulatory environment. Regulatory environment is background at best. So what is being relied on here is a discrimination claim, contrary to Article 7 RTC. And what you need to look at, in my submission, is
just to make sure that we're clear. When I spoke about different regulatory environments, I was saying that Trinidad and Tobago has a particular regulatory environment, and the Bahamas has a different regulatory environment, and Antigua and Barbuda, and so on, so that the regulatory environments would differ as between these various different jurisdictions. Yes?
Yes.
So I wasn't speaking specifically and only about the regulatory environment in Trinidad and Tobago. I hope I'm understood.
I I hope I have the point. And I hope the following is an answer to it,
Yes.
which is that I think it also came out of some of the evidence that a lot of the claims, or at least forgive me for not being able to take you to the specific minute of it, but I think to take it put it bluntly, didn't care about the regulatory environment when they were making their investment decision. Maybe they should have done. Maybe they should have, with the benefit of hindsight, examined the situation much more carefully than they did in the end. But the bulk of the investors, consumers, in particular in this case, were not sophisticated investors who would have gone to the background, informed themselves. Is there a statutory fund? Is the statutory fund paid up? How safe is this investment?
I follow you, but as a matter of fact, isn't it quite likely that the regulatory environment would have differed as between the different jurisdictions?
I'm with you, Your
Okay.
Honor, indeed.
And would that difference not make a difference from the point of view of saying that the discrimination was not on the basis of nationality only? That there are other things that you could take into account which would account for a difference in treatment of the policyholders in Trinidad?
Your Honor, I don't think in my submission that you can draw that distinction. And that is simply because the regulatory environment was not relevant for the decision of the claimants to exercise their rights under the RTC. As I was seeking to make the point, the claimants did not inform themselves about which regulatory environment. In other situations, that might have been a relevant case. But in the context of this case, in my submission, also because there is no reliance placed on the regulatory environment being prejudicial or advantageous at all. The question of the statutory fund shortfall is not something that is at the core of this claim. Of course, it would have been nice, to use the euphemism, if it would have been nice if the statutory funds had been up to date and had been up to date in all the jurisdictions. The fact of the matter is, as we heard, that wasn't the case. There were shortfalls across the region. And these shortfalls were not such as to influence the investment decisions in the first place.
So your point is just to disregard all of these multiplicities of jurisdictions, regulatory environments, requirements of statutory funds, the establishment and operation of judicial management, all of those things, disregard those, and just simply focus on the fact that these persons purchased policies which were comparable. Is that your... Yeah.
I think you put it very well.
I understand.
Because that's what the claim is about. I'm not ruling out that in other claims, the regulatory environment might become hugely relevant. But in this case, it isn't. That's precisely my point.
Mrs. Ashler, if the treatment that is different is premised on whether you are a policyholder of BICO or of BAT, is the discrimination targeted on the policyholder or on the company?
Mr. President, it's a very good question. I think you can anticipate that I'll take both of those distinctions, if I may. I think the obvious one is that BICO policyholders didn't receive any funds out of the CLF group pot, if I may call it that, because BICO was a non-Trinidad company. That is the reason on the record, and that is the reason why the Trinidad and Tobago government didn't consider them as being part of the eligible persons who could get any money out of them. So there we have discrimination on the basis of nationality, because for companies, I don't think this is a point I need to labor, but in the case of companies, evidently it's a place of incorporation registration that serves as a shorthand for the nationality. So BICO was discriminated against on the basis of nationality. And by the same token, second part of your question, Mr. President, I would also maintain that indeed there was discrimination on the basis of nationality against policyholders, because the vast bulk of the policyholders of BICO, where, in fact, I think I'm right in saying that all of them were non-citizens, non-nationals of Trinidad and Tobago. Whereas in the case of BAT, well, we've heard the number, I think it was 13 of the policyholders of BAT who were non-nationals of Trinidad and Tobago.
But neither BAT nor BICO, in the case of BICO, did not have any regulatory provision that says to be a policyholder, you have to be a non-Trinidadian. Nor did BAT have anything similar. To be a policyholder, you have to be Trinidadian. So in a sense, it's coincidence, it's happenstance that most or all of the policyholders of BICO were non-Trinidadian. I don't even know if that is correct. But
I'm not saying, and I don't think I need to say, that there was an intent behind the discriminatory treatment at the end of the day. I'd piggyback on what Mr. Davenport said this morning, his pay discrimination example, analogy. If, at least this is the way it works in the European Union, I can't claim to know the framework here in detail yet, but if it appears that you have two groups of employees who are doing work of equal value, and you find out that one of them is paid less, and it so happens that the vast majority of them are women, then you have discrimination on the basis of sex. And that is something that that doesn't require any further proof of intent, of ill will. It's just a fact. You might then be able to justify it somehow at the end of the day, or ideally, it's very hard to justify that sort of finding. Evidently, needs to be rectified. But I don't think. I don't think once you have the statistical evidence, which is overwhelming, that there is one group of policyholders who were non-nationals, and they were treated less favorably than another group of policyholders, almost all of whom were nationals, then you have differential treatment for the purposes of Article 7 RTC.
So it doesn't matter that there are exceptions. In other words, it doesn't matter if there were a few who were nationals or non-nationals, as the case may be. You look at the group as a whole, and if you look at the group as statistically, I don't know, is it 80, 90%, the vast majority are in a group. It could be based on gender, it could be based on any distinguishing feature or salience. That comparison can be made, and you can claim discrimination.
Your Honor, absolutely. And I think the word statistic is key to a large extent here. And I think that's also the term used in the Myrie No. 2 judgment, where what was looked at is what is the statistical situation. Of course, the claimant in Myrie failed on that basis because she wasn't able to show that the statistics demonstrated discrimination. We've got the opposite. We have a very, very clear case of differential treatment on the basis of nationality. If you look at the statistics, 13 versus, I forget the
27,629
versus, I defer to Mr. Davenport, 27,000. So I think it could be clearer that there was differential treatment on that basis.
Hey, can I just ask you one question on that then? So is this then a sort of a proportionality evaluation? You say you're talking about statistics. In other words, if the treatment is disproportionate according to a group, because is it 51? Is it 81? Is it, how do we assess that? Okay, so you say 13 out of 3,000. I mean, you know what I mean? Is it that this is a sort of a proportionality approach where you look at the groups and you say, when we look at the comparators, this is discriminatory because clearly there are, is it a majority or a vast majority, or how is that assessment? 51-49, is that discrimination? Yeah, I think you get it. Yeah.
Your Honor, I'm tempted to take the easy way out and saying here we are nowhere close to 51-49.
I get that on the figures, but you have to at least frame the theory.
Absolutely. I would say proportionality probably doesn't come into that. I would see proportionality being more in the question of the degree of disadvantage. So the pay differential, if you take the gender discrimination case. If there's only a difference of $5 a month, is that really discrimination? I think that's where proportionality comes. Whereas if you have a set, sizable, obvious difference in treatment as you have here, because either people received up to maybe 20 cents on the dollar, probably nowhere close to that, and others close to 100%. That's the proportionality bit. So it's an obvious distinction. And then you look at your numbers, and I can entirely see if it's 50-50, or if it suggests that it's by chance into whether you benefited or didn't benefit. Then obviously it would be difficult to find discrimination. But here, my short point is we're nowhere close to that. As regards language, I don't know whether Your Honour is already thinking about establishing a test as regards that. But obvious preponderance could be such a test. The obvious majority. It would have to be clear. My short submission is that in this context, it is clear. I was reminded, this goes to a slightly earlier point, that actually there was no evidence heard as regards differences in regulatory environments in any event. But I think the short point is it didn't influence the investment decisions in any event.
How would you reconcile that general theory that you put forward with cases like the Ryanair, which was mentioned to us earlier, where the European Union, the ECJ, seems to have sanctioned aid to just one of several different undertakings?
Yeah, I think state is a very good example. And as we put it in our written submissions already, we see it as supporting our argument, because precisely state aid is carefully structured in such a way in the European Union so as to precisely still preclude discrimination on the basis of nationality. Anything as crude as that, and that happens through a number of layers of checks and balances. The most obvious one is that Commission approval is required. And my learned friend took you to Articles 107 and 108 of the TFEU. It may be worthwhile having a quick look at those again, actually. The fact that a supranational authority that, except of course doesn't exist here, but it has to actually give its stamp to approval before state aid is permissible to be paid in the form of the Commission, guarantees to a large extent the fact that there is no discrimination, because that's going to be one of the factors to be taken into account by the Commission. In fact, there's case law on this, which only comes up now, but there's the Nuova Agricast case. Maybe that's. Do you have that? I think you can see it there. That's a state aid case. As you can see, it's a Grand Chamber decision of the Court of Justice and I apologize for not having it in the bundle, but it came up here in argument, of the 15th of April 2008. It's a state aid decision. I just need to take you to paragraphs 50 and 51, which make the point that in state aid, so I hope you can read it. Is it possible to have it slightly larger? So it is clear from the general scheme of the treaty that the procedure under, this is Article 88, EC is the old 108. So what my learned friend was taking you to in terms of 108, that's the procedure that's referred to here. Must never produce a result which is contrary to the specific provisions of the treaty. Of course, non-discrimination is one of those specific provisions of the treaty. Then it cites case law. Accordingly, state aid, certain conditions of which contravene other provisions of the treaty cannot be declared by the Commission to be compatible with the common market. And then 51 drives home the point. Similarly, state aid, certain of the conditions of which contravene the general principles of community law, such as the principle of equal treatment, cannot be declared by the Commission to be compatible with the common market. So there's a very express prohibition on discriminatory state aid. So the Commission,
What
if
year
it
was
granted
this? What
Ryanair-
year was this case, Council?
this is a 2008 judgment.
And what
Grand
year
Chamber.
was the Ryan?
I apologize.
What year was the Ryanair case? Was that? I think the
Ry-
last decision
Ryanair-
was
Ry-
last year, 2023, was it not?
Ryanair is a later decision. It is a more recent decision.
Yeah, the
but-
fourth chamber, I think, gave its decision last year. As I recall.
Well, in Ryanair, I have to confess, there is a string of Ryanair cases. It's an extremely litigious company.
Indeed, yes.
And therefore it's difficult to keep track. But indeed, I think 2021 case that I'm taken to, of course, which was first then.
Well, there's also a 2023 case from the fourth chamber. That's beside the point.
But I think the important point, and this is borne out actually also by the Commission notice that was cited by the defendants in written submissions, and we responded to briefly by complementing it in our reply, written submissions and reply. The Commission notice is also quite express about the fact that you can't have discrimination in a state aid context. I think it is all in our written observations, written submissions. So I don't think I need to take you to that back. What I might briefly take you to is Article 108 again. You saw that just a moment ago on the screen. And it obviously, the way it works in EU law is that 107 are the substantive provisions for granting state aid, with, as you saw, 107(1), the prohibition as a matter of principle of state aid, and then 107 paragraphs 2 and 3 containing derogations from that general prohibition, supposing, of course, that other provisions of the treaty are complied with. Article 108 is a procedural provision, so it's the procedure for the Commission actually giving its approval. And I simply, for the sake of completeness, wanted to take you to the last sentence of subparagraph 3, because I think it stopped on the screen at 108.2, and 108.3, the last sentence, in my submission, is quite important because rams home the principle that state aid should not be implemented unless the procedure has been followed. So unless the Commission has given its stamp of approval. So it reads, the member state concerned shall not put its proposed measures into effect until this procedure has resulted in a final decision of the Commission.
I hope CARICOM is listening, because it seems as if there are some institutions that we could perhaps benefit from, which we don't now have, unfortunately, in CARICOM.
I'm glad to hear that. But so my short point on state aid is the state aid framework is of assistance to us because it shows the number of checks and balances that are in place to exclude, even in that context, discrimination on the basis of nationality. Let me just see, unless there are other questions on this point, but I was going to come back to comparability. So where we left off is it's in the context of deciding whether situations are comparable. You have to look at it from the claimants. You have to look at it from the point of view of the claim that's actually being brought forward. And it's the obvious point. It's not sufficient to just identify differences. The question is whether the differences that are identified are actually relevant. And here, I think we've got a situation which is actually rare when you look at discrimination cases, where there is a very obvious and clear comparator for BICO, BAT, selling the same products. I don't need to labor all the details. Mr. Davenport had already taken you to those. But so where you have such an obvious comparator, that's the obvious starting point for the analysis. So one doesn't need to go into CLICO and wider comparators. I mean, just to sum up on that point, we're effectively saying that the claimant's money, BICO money, ended up, as you heard, in the CLF pot. And they should have been entitled to get their liabilities defrayed out of that pot in the same way that others notably BAT policyholders, who are the best comparators, did. Just to round that off, obviously, I'm going to submit that the only relevant distinction here was that the question of nationality, whether you put it on the company level, BICO versus BAT, or at the policy holder level. Then motivation, I think we'd got into to some extent already, but this is really just to insist that the reason why the state is imposing something doesn't really, for these purposes, matter. What matters is that there is difference in treatment that you see. I mean, if you take another, maybe not, well, quite simple example, if the state decides to exclude immigration of non-nationals in order to shore up national employment, for example, because there is an unemployment crisis, that's still discriminatory, notwithstanding the fact that one can understand why they're doing it, and that's being done for good reasons. And Your Honour asked the question about national security. And again, national interest, I think, is the way Your Honour put it. My submission is also, national interest doesn't displace the RTC. The starting point is there a right in the RTC that is restricted? Yes or no? The Cowan case, which we cited in submissions, is a good example of that. The Cowan case was a British tourist who in Paris, on the Paris Underground, had an accident or was even attacked. And there were criminal procedure rules, and evidently criminal procedure is not harmonized in the EU treaty. These criminal procedure rules provided for compensation only for nationals, and this is criminal law. And the court simply was not interested in looking at where the rules came from. The question is, what was the effect on the claimant? And it meant that Mr. Cowan, on the face of it, wouldn't have been able to get compensated. And that was the end of it, because that made out the restriction in that case.
You need to wind up, Mr.
Now, I ought to still deal, if I may, with the
How
consumer.
much longer do you intend to be, Mrs. Ashley? Because you run out of time.
Could I get 10 minutes, do you think? Thank you. I'm grateful, Mr. President. On consumer, there's one very short point, the goods and services point, and was already dealt with by my learned friend a moment ago, based on the Insurance Act. I think I can add to that, and I haven't looked it up to bring it up on screen because it's a very simple point, that as a matter of the case law of the Court of Justice, namely case 184/83, Grisoli and Banque Internationale pour l'Afrique Occidentale, but I think the case number will get you there. So 184/83. It is clear that free movement of financial services is a service indeed, and it doesn't fall within the goods provisions. And Mr. Davenport already mentioned the WTO rules. It's the GATS agreement, General Agreement on Trade and Services, that's relevant. That has an annex on financial services, and I'm not going to take you to that here, but because it is a rather short point. Article 5 of which also makes clear that insurance services are covered by GATS, that is the General Agreement on Trade and Services, not the GATT and the goods provisions. That's a short point on consumer rights. The longer one, slightly longer one, is on the concrete nature of the rights that you need under Article 184 and specifically 1J. Now, I think we entirely take the point that there's a long list of rights listed in Article 184, paragraph 1, and not all of them are sufficiently concrete to give rise to immediate application, to give rise to rights that are actually enforceable. What you need to do is, like with any other treaty provision, is you need to look at the words, you need to look at the context, and at the objective pursued by those words. And our submission is simply that when you're dealing with J, J deals, the heading of all of this is promotion of consumer interests and so on, but J deals with redress, with remedies. And that is actually quite specific, I would submit. I mean, to a lawyer, and this is obviously drafted by lawyers for lawyers, redress has a clear meaning. We cited the nice Latin maxim, ubi jus, ibi remedium, in our submissions. But it is really an enunciation of the very simple principle that where there are rights, there ought to be a remedy that's actually also available. And the sort of remedies that you can grant is not an open-ended list. It's not vague as regards what you need to do in order to comply with that. So that already makes this particular provision rather more specific in my submission than the other provisions. So it's not an open-ended term, the concrete nature, how concrete it is, I said, arises also out of the context. Should always interpret provisions obviously in their context, and it can be made more concrete by the circumstances, by the development of community law as the community submit it. Obviously, if there is legislation, if there's specific measures that can make that more concrete. But that's not necessary in my submission. It can also be made more concrete by the development of general principles of community law. Simply in the case law of your court, for example, like, for example, in this very case. That is something that's not unknown to the European Union, where, for example, the fact that, well, we were talking about gender equality and the pay discrimination provisions of the treaty, they were made concretely applicable for the first time.
But general principles would have to be developed from a survey of the municipal systems which exist within the region and trying to find some sort of commonality. I don't believe that through the course of this hearing we have been exposed to any such possibility, have we?
Your Honour, you're quite right, and that is not something I was going to rely on. I wasn't going to say that there's been a development that you need to take into account here in general as regards community law. I'll cut to the chase. What I was going to rely on is the fact that actually here there's been a very concrete national measure that's been taken. Trinidad and Tobago defined in its national legislation what redress was going to be given to policyholders of, well, for example, our comparator BAT. And it then specifically excluded policyholders of the claimants, or the claimants from that redress. And we take a number of points, but for present purpose, we take 2 points out of that. First of all, there again is differential treatment on the basis of nationality. So redress is granted, but there's a carve-out from that redress which affects only non-nationals. That's the first point. And the second point is what you could label a non-regression point. So even if you're not with us, there's a need to introduce additional rights. I think the one thing that we should be able to agree on is that regression is also not permissible. So while maybe no concrete measures need to be taken in addition by virtue of Article 1841J by a particular member state, a member state should not be permitted to move back from progress it has already made. So that's generally referred to as non-regression principle in EU law. One could tie it here to Article 9 RTC as well, so loyal implementation, and it ought to be a community of progress rather than regress. And what we say here is, of course,
very controversial doctrine in many places, non-regression, and I certainly have not seen it mentioned in our treaty, and I'm very happy to hear it from you as something to think about. But I'm just telling you, as far as I'm aware, that's not something that we have.
Your Honor, you're quite right, probably, that we didn't use the label in the pleadings, but we did quite clearly, I think, set out in the third claim that the removal of remedies available, the curtailment of remedies, was one of the grounds of the claim. I think we had subdivided into 3. So this is something that we do have in the papers. We may not have attached the non-regression label to it, but this is
No,
maybe
I wasn't
clarifying.
thinking so much of your submissions. I was just thinking generally that is a concept, which I know is very fashionable, particularly in environmental law, and which has come into some very interesting discussions there. But in the context of our common law systems generally, it is not one that I think we have certainly applied very often. And certainly, as far as I am aware, I don't think we have come across it in the regional situation. So, but thank you for raising it. Interesting.
Your Honor, there's always a first time, I'm bound to say.
Yeah, of
for
course.
these sort of things.
I want to just tackle you a little bit on 184. The impression I get from reading 184 is that it requires member states to engage in a particular norm. We can't read J as if, well, in any situation that arises, you must provide redress, adequate and effective redress. But that rather, Article 184 is encouraging, requesting states to provide mechanisms for promoting the interests of consumers. So if we assume that, okay, your clients, the policyholders, if we assume that they are consumers, they are persons who purchase this financial product, a suitable mechanism, for example, might be to have a regulatory system where you have a deposit requirement that ensures that persons who purchase these instruments will be satisfied if there's an issue. But I don't know that 184 stretches to suggest that in any given situation, a state is under an obligation to provide redress for citizens, community nationals throughout the community. How do you respond to that?
Mr. President, I wouldn't necessarily disagree with you. And this is the question of to what extent is there positive obligation to actually do more. The point we're making is that if a member state acts, and it acts in a way that can be subsumed under the field of application of 1841J. So in other words, it's providing redress. The member state is acting within the field of the treaty, and it therefore needs to comply with the framework of the treaty. And that framework includes Article 7 RTC. And therefore, when a member state provides redress to consumers, it may not have to. With you, Mr. President, on that, it may not have to actually act. But if it does act in that field of application of Article 184, then it has to act in a non-discriminatory manner. And what we're saying is that Trinidad and Tobago acted, provided redress, but it breached, in so doing, it breached Article 7 RTC. That's how these provisions here fit together.
So if it had done nothing, then it would be off the hook.
Yes.
But it cannot do something to protect the policyholders who took out policies with companies registered in Trinidad and Tobago.
Mr. President, this ties in quite nicely, actually, with the question we had as regards the potential hypothetical asymmetry in the development of consumer protection law. And we had the hypothetical example posited, what if all member states, apart from one, had actually acted? And in those circumstances, my submission would simply be, well, the member states that had acted would still be bound to apply the progress which they had enacted in their statutes books in a way that is non-discriminatory. And even citizens of the one country that hadn't acted would still be able to benefit from that when they travel to other member states, because there's no reciprocity requirement within the RTC. So that's a short point on that.
Mr. Zashler, you have 2 minutes.
Thank you, I'm obliged. I think I can conclude this consumer angle by saying that basically when the community therefore argues that Article 186 needs to be triggered, and the framework needs to be put in place. I would respectfully disagree, at least regarding the fact that the clarity and the certainty and the concrete dispositions can also be provided by national law. They don't have to be provided by community law. We don't need an additional framework simply to say it's non-regression. But I'll leave it at that point rather than expanding there. Final point, coming back to the one jurisdictional point as regards to the 100 million US dollar claim. I think it is quite clear that this is not something that can be brought inside Article 184. I would maintain Article 9 is would in principle be something to hang that on, but I take the point that Article 9 we would need a special indulgence of the court in order to bring that forward. I would simply end by saying that one can tie the $100 million claim also under Article 7 RTC, particularly if you accept that that can be relied on independently. And that's simply on the grounds that Trinidad and Tobago, having procured for its nationals nearly 100% of their investment, is withholding from other nationals, other member state nationals, the balance of $65 million at a time when it knows that they have only received 14% with possibility of receiving 20% on the dollar. So there is a potential other hook. And I would yield back to Mr. Davenport if...
There's nothing to yield back.
Sorry.
Bye.
I'm much obliged.
Yes. Now, any cases that you, not any, those cases that you did mention, of course, you will make them available both to the court and to the other side.
Yeah.
Yes. Well, thank you very much. Mrs. Speaker.
President, may I just take 2 minutes response to the challenge that
I think you better come to the mic, Mrs. Speaker.
Sorry, I didn't intend to be long. The challenge was that there was no evidence of any assets of BECO being used to fund the bailout. And my learned friend gave you 3 distinct situations. The first of them was he said the entirety of the BAT shares were used. And I wanted to point out that the MOU at page 5043 did speak about government receiving appropriate shareholdings in CLICO and BAT. But there is no evidence that any shareholdings of BAT were ever transferred to GOAT. And in fact, it was never done. So there is no factual basis for any suggestion that BAT shares were used. And we dealt with this at paragraph 36 of our submissions at page 10891. The second item that he said was evidence of assets of BECO were used. He referred to the deed of settlement with BECO and CLF, which is referred to at paragraph 138 of Ms. Leachy's witness statement, which we'll find at 5505. But if you read that paragraph, there's nothing in there to suggest that any assets of BECO were used. What happened was that BECO sued CLF in the courts of Trinidad and Tobago under a promissory note, and because government feared that if a judgment was taken up, the CLF could be wound up, the debt was assigned to government, and government ended up paying BECO a total of $52 million US. So there, again, there's no evidence there of any asset of BECO being used to fund the CLF bailout. And the third example he gave was the reference to the CLICO Energy shares, and you will see that at exhibit SLC 12 to the witness statement of Ms. Leachy, and it's up on the screen. First of all, the date is January 18, 2009, so it's pre-bailout, and this is a letter being written by BAT to the Inspector of Financial Institutions in Trinidad and Tobago, and my learned friend referred to paragraph 2. where it is being said in an effort to comply with Section 37(6) of the Insurance Act and eliminate the statutory fund deficit referred to in your letter, BACO is willing, this is pre-bailout, to place up to 9%, that is, and they quote the number of shares, fully paid up ordinary shares of Clico Energy Company Limited in the statutory fund. Again, no evidence that any such shares were placed in the statutory fund, and in any event, that is no evidence of, BACO's assets being used to fund the bailout. So in our respectful submission, my learned friends have not made good the submission that any assets of BACO were used to fund the CLF bailout. That's all I wanted to be clear to you on.
Yes.
And those are respectful submissions.
Yes, thank you very much.
Thank you very much.
Well, naturally, the court will take time for its decision in this matter. I want to thank counsel for your submissions, and in due course, we will let you know when we're in a position to render judgment in this matter.
Right.